Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. For today's story, we're covering a Supreme Court oral argument on the availability of a common pill that is used for abortion. There is controversy as it relates to this case regarding the FDA's expansion of the availability of this medication. The medication had been approved in the 90s under certain terms, and that were the terms that were going on. And then the Biden administration attempted to expand out the terms for which it would be available, most notably by changing the period by which the medication could be taken and trying to expand out its use. The problem is that the FDA may not have gone through the proper processes to do so by law. There is a process, as one might appreciate, to approve a drug or to formally change its usages. Right? So we're not talking about what can be done or cannot be done. We're talking about the medication in terms of how it's approved and what it's approved for, and the restrictions there too. So when a medication is approved, that comes with certain terms. And if you want to change those terms, there's a process for that, as you would expect, because it's an administrative act. So the problem here is the expansion of the use, whether or not that was done properly or whether or not it was done improperly. And that is the issue brought before the issue in the case of the Food and Drug Administration versus the Alliance for Hippocratic Medicine. Let me read the facts of the case and the question presented. The facts of the case are thus. Medication abortion in the United States is commonly conducted using a combination of Mifepristone and misoprostol. Mifepristone was approved by the United States Drug Administration in December 2000. I believe that's RU 486, if memory serves correctly, and is used in over half of all U.S. abortions. Initially, its distribution was limited to hospitals and medical facilities under the FDA regulations. So if you wanted to use this medication, you had to go and use it effectively at the doctor's office. The 2007 Food and Drug Administration Act introduced a risk evaluation and mitigation strategy review that reinforced the FDA control over drug approval. So the FDA still has the power to review drugs, and we modified a little bit how that goes about through law. Despite the review in 2011, Mifepristone's distribution remained restricted. So again, the drug was initially approved, but it had to be used at a doctor's office, at a hospital, at a center. And so there was a process by which the FDA could modify its approval. That the process for modification was, at least in part, changed in 2007 by law. And the FDA went through that process, as one does. And at the end of that process, the distribution remained restricted under that particular process. All right, so that was 2011. In March of 2016, the FDA expanded access, allowing medical practitioners to prescribe it and extending the usage period in pregnancy. So those were two critical features. First, it no longer had to be taken at the doctor's office at the hospital. It now could be prescribed, so you could take it on your own. And perhaps more critically, although it depends, I suppose, who you ask, it expanded out the time period by which it could be used. These medications are used in very, very early pregnancies. Not only are there's risks in using them in later pregnancies. There's increased risk to the woman, and there's also other increased risks by expanding out the period. Now, there's a cost-benefit trade-off, and I'm not a doctor, so I'm not here to speak to whether or not it's worth it or not. That is not my domain. But I can say that they expanded access in a way that looks like it doesn't comply with the law. They didn't go through the proper procedures for such a thing in sort of how to evaluate that. All right, so that was 2016. In April 2021, due to the COVID pandemic, even more critically, the FDA permitted mail distribution from certified sources, and in January 2023, approved pharmacies also beginning to distribute it, which is also a problem because there's a separate act. I believe it's called the Volstead Act, or maybe that was just alcohol. I'd have to double check, but it doesn't really matter. Either way, there was an act of Congress that in the early 20th century that appears to ban the mailing of abortion medication. And this medication was obviously approved well after that ban was put in place, but still the ban remains. And so it looks like this is not allowed because there's an act of Congress from the early 20th century that seems to say, by its explicit terms, that you can't mail abortion medication. It's just not allowed. Okay, but the FDA allowed it anyway, despite the act in the, because they did that. So that's the problem. All right, so we got a problem on a couple different levels, just to summarize this. We got the initial approval. The initial approval is not the problem. So in 2000, the drug is approved. That is no longer the problem. No one is contending that's the problem. So if we just did it under the same terms as it was in 2000, no one contends there's a problem, at least not anymore, right? Maybe they contended there was a problem way back when, but that ship has sailed, right? What we're concerned about is the potential improper expansion of it. We're concerned about the improper expansion despite its own internal review process. So its own internal review process said, keep the restrictions. But despite that, we said, how about we're going to expand it anyway? And then we started shipping the stuff in possible violation of law. So that's what we're concerned about. All right, reading on. However, following the Supreme Court's decision of June 2022 in Dobbs versus Jackson, which eliminated the constitutional right to abortion, several states sought to restrict the sale, which makes sense because, we don't allow abortion in our state. It's our choice now, and we don't want your drugs in our state. Cool. The Alliance for Hippocratic Medicine and other anti-abortion groups challenged the FDA approvals, claiming inaccurate consideration of the evidence in 2000. So they're trying to go all the way back to 2000, but I don't think that's going to work. They're trying to go all the way back to 2000, but I don't think the Supreme Court's going to go for that. So I don't think that's going to, good luck on that, trying to go all the way back to the original approval. I'm not saying it was super clean or there weren't issues to complain about, but, it's like, dude, you want to go all the way back to 2000? I don't know about that, but they're trying. Okay. In April 2023, a federal district judge sided with the plaintiff, suspending the approval. The United States Court of Appeals for the Fifth Circuit partially stayed the decision, maintaining the original 2000 approval, but striking down the 2016 changes that eased access. So the district court actually went for striking down the approval all the way back to 2000, which is aggressive. The Fifth Circuit took a slightly more moderated approach of, okay, we're not going to touch the original approval, but we'll touch the expansions because, there's that. After a hearing on the merits, the Fifth Circuit continued the ban as it relates to the modifications. So the Fifth Circuit's like, you can continue using it as it originally was, but you can't do any of this new stuff, including mailing it. Okay, that's what the Fifth Circuit said. The United States Supreme Court granted review and stayed the lower court's injunction. So the injunction for the moment is stayed. So at the moment, the medication can be prescribed, mailed, and everything else because the stay is enjoined while the Supreme Court considers the merits. Thus, the question is presented as thus. Do the respondents have Article 3 standing to challenge the Food and Drug Administration 2016 and 2021 actions with respect to the drug's approved conditions of use? So standing is always a good question. Do you have standing? Probably, but they're going to ask anyway. 2020 or number 2. Were the FDA's 2016 and 2021 approvals of the Mifepristone arbitrary and capricious? The government can't do arbitrary and capricious, like basically ever. They need at least rational basis. So they're trying to argue they're actually trying to say that it doesn't even meet rational basis review, which is pretty hardcore. And number 3, did the district court properly grant preliminary relief? Which I'm not sure what it matters at this point either way. But, fine. So that's what we're trying to decide, it seems. We're trying to decide whether or not the FDA messed up in 2016 or 2021 with respect to the expansions. Okay. So we're going to listen to this oral argument and hear what the arguments have to say. Now, my view of this, is that the mailing is the most problematic legally. It seems to me, because it seems like there's a law that says specifically you can't do this. And, you can't just go against the clear text of a statute no matter how old it is. So the statute may be antiquated, it may not, but it's still the law. And so, I think that's the easiest one. And then as to the processes that they went through, if they completely bypassed their own review, their own internal review, because their own internal review said don't do it. And so they're like, we're going to do it anyway. That seems kind of arbitrary. Because, why? Because we want to. That seems kind of arbitrary, right? So I think the mailing component remains banned. And as to the expansions, I suppose it depends on the details. But we're going to listen to the oral argument and see how my opinion is modified or refined. So let's go ahead and get started with this.
We will hear argument this morning in Case 23-235, the Food and Drug Administration versus Alliance for Hippocratic Medicine, and the consolidated case. General Pilliger.
Mr. Chief Justice, and may it please the Court. FDA approved Mifepristone based on the agency's scientific judgment that the drug is safe and effective. It's maintained that judgment across 5 presidential administrations, and millions of Americans have used Mifepristone to safely end their pregnancies. Respondents may not agree with that choice, but that doesn't give them Article III standing or a legal basis to upend the regulatory scheme. At the outset, respondents lack standing. They now concede they can't rely on a statistical theory of injury like the lower courts did. Instead, they have to identify a specific doctor who faces imminent harm. But their theories rest on a long chain of remote contingencies. Only an exceptionally small number of women suffer the kind of serious complications that could trigger any need for emergency treatment. It's speculative that any of those women would seek care from the 2 specific doctors who asserted conscience injuries. And even if that happened, federal conscience protections would guard against the injury the doctors face. And there's no basis to conclude that any of that would be traceable to the incremental changes that FDA made in 2016 and 2021, as opposed to the availability of Mifepristone in general. Respondents' theories are too attenuated as a matter of law. The Court should say so and put an end to this case. If the Court reaches the merits, FDA's actions were lawful. The agency relied on dozens of studies involving tens of thousands of women. Respondents don't identify any evidence that the agency overlooked. They just disagree with the agency's analysis of the data before it, but that doesn't provide a license to authorize judicial second-guessing of the agency's expert judgments. Finally, on remedy. The relief entered below would severely disrupt the federal system for developing and approving drugs, harming the agency and the pharmaceutical industry. It would also inflict grave harm on women across the nation. Rolling back FDA's changes would unnecessarily restrict access to Mifepristone with no safety justification. Some women could be forced to undergo more invasive surgical abortions. Others might not be able to access the drug at all. And all of this would happen at the request of plaintiffs who have no certain injury of their own. The Court should reject that profoundly inequitable result. I welcome the Court's questions.
My love affair for Solicitor General Prologar continues, unabated. Her framing of the issue is perfect. She's just so good at laying this out in a very concise way. She gets 2 minutes for free under the current rules. So the Supreme Court changes its rules from time to time, as one would expect. So under the current version of the rules, she gets the first 2 minutes for free. The justices can't ask questions for the first 2 minutes. That didn't used to be the case. It used to be the case the justices could ask questions immediately, and often did. But they changed the rules a couple years back, not that many years back at this point, but you get the first 2 minutes for free. And so she's like, how do I give basically the perfect 2-minute summary of my case? I mean, she's good. It's hard to conceive of how you could do any better. It's like I'm desperately looking for any way to fault her. Like just on a professional level, I can't do it. She's just too good. So, I mean, that isn't to say that I'll agree with her at the end of the day, of course. It's just to say that her framing, control, and presentation is perfect. So, yeah, so good.
General, if we agree with you on standing, could you give us an example of who would have standing to challenge challenge these FDA actions?
As a general matter, we've seen lawsuits in the past that are brought by, for example, prescribing physicians or patients who want greater access to a drug. Sometimes we've seen theories of competitor standing, where a competing drug manufacturer might sue and claim that FDA's approval of a drug creates a competitive harm or injury in that sense. Justice Thomas, I think that if the question is whether there would be individuals who generally oppose abortion who would have standing and want to challenge FDA's actions, the answer to that is no. But the reason is because those people aren't regulated in any relevant way under FDA's decisions here. Take these respondent doctors. They don't prescribe Mifepristone. They don't take Mifepristone, obviously. FDA is not requiring them to do or refrain from doing anything. They aren't required to treat women who take Mifepristone. FDA is not directing the women who take the drug to go seek out care from these specific doctors.
Yeah, that's pretty
and so
good.
They stand at a far distance from the upstream regulatory action they're challenging. And the court has said in many cases that in a situation like that, when you are not the direct object of the agency's regulation, it can be substantially more difficult to establish standing.
That's pretty good. That's pretty damn good. And she's not wrong. It's like, how are the doctors who are bringing this lawsuit harmed? How are they harmed? They're the ones bringing the lawsuit. How are you harmed, doctors? The FDA isn't making you do anything. They're not requiring you to prescribe this. They're not requiring you not to prescribe it. They're not requiring you to treat these women. They're not requiring you to not treat these women. They're not doing anything to you. Like at all. Even a little bit. And also, by the way, incidentally, and for its worth, as the Solicitor General mentioned in her introduction, there is a federal law specifically granting the doctors additional protection for exactly this reason, the conscience right reason. So not only they're just generally protected anyway, but there's a special federal law granting them special protection. Hey, doctors, I know normally you don't have to do anything anyway, but just in case anyone was confused, here's a law specifically saying you don't have to do anything. You're allowed to not do things because your conscience objects. That's cool with us. We don't care. As the FDA. Now, whether or not your state cares or whether or not someone else cares is a whole nother set of problems. Someone else may care, but of course we're not suing them right now, are we? We're not suing someone else who might care. We're suing the FDA. And the federal government's over here like, we don't care. As far as we're concerned, we don't care. Prescribe the drug, don't prescribe the drug. Treat the patients, don't treat the patients. Treat the patients, but don't give them the drug. Do whatever the hell you want. We don't care. So how do you have standing? That's a pretty decent question. That's a pretty decent question. Yeah.
Criticism of some of our associational standing cases and organizational standing cases?
I don't think it is for a couple of different reasons. With respect to associational standing, this court has said time and again that the association needs to identify a specific member who is suffering a concrete harm, a cognizable injury that's non-speculative. And I don't take respondents now to take issue with that fact. They're agreeing that it would be necessary to come forward and identify a specific doctor. The problem with their associational standing theories is that they rest on this chain of remote possibilities, so many different steps in the process that would have to occur, each one layering one speculative remote odds of a chance of injury on top of another to get to the...
I don't know who said doctors can't sue their licensing boards, but you absolutely can, by the way. They're the government too. Yeah, doctors can absolutely sue their licensing boards. Now, I'm not sure what hypothetical we're suing them for, but yeah, it's possible for the licensing board to violate the law, and it's happened. It's happened with lawyers, by the way, incidentally. Lawyers have sued the bar and won in certain jurisdictions. Yes, doctors can in fact sue their licensing board because the licensing board might do illegal things. They are the government after all. Of course you can sue the licensing board. You just have to have a basis to sue. So yeah, I mean, if the licensing board said you must do this, then yeah, you could absolutely sue. You probably would win, incidentally. But I don't know. That's a whole other set of problems, right? That is not the hypothetical we're dealing with. Right? We're not dealing with the state of whatever says you must do this. And the doctors are like, nah, we're not all about that life. We're going to sue the damn board. You can't make us. And maybe they're right or maybe they're wrong, but it doesn't matter either way. It's not what we're dealing with, right? Yeah.
on top of another to get to the ultimate harm they're claiming on behalf of these doctors.
Well, you emphasize the remote nature of the injury, the small number of adverse effects, the likelihood that the patients will go to the emergency room, and so on. Is there a number at which your argument would change? The significant number of consequences, a higher likelihood of an emergency room visit, doctors who spend more time in the emergency room. At some point, does this analysis lead to the other result?
It's hard for me to imagine that it could, and there are a couple of different reasons for that. I take the point that you might pick out different links in the chain and suggest that there are ways to wildly depart from the facts here and suggest maybe as a statistical matter, one or two of those events could be probabilistically more likely to occur. But we have an objection here to the underlying theory as a legal matter because it rests on so many different things that would have to happen one on top of another and that turn on independent decisions made by third parties who are strangers to this litigation, who are not part of the suit. So we think that brings the case within those like Clapper or Summers, where this court has recognized that when the theory of injury really turns on so many different intervening events separated by independent decisions, it can mean that there is just an insurmountable hurdle to establishing standing.
Could you provide a more specific answer to the first question that Justice Thomas asked you? Is there anybody who could challenge in court the lawfulness of what the FDA did here?
In this particular case, I think the answer is no.
Well, that wasn't my question. Is there anybody who can do that? Let's start with the states that intervened below. Will you say in that litigation, fine, you can challenge it, and let's get to the merits of this issue, the lawfulness of what the FDA did?
No, we think the states lack standing. They're asserting indirect injuries that would, if it provided a basis for standing, mean that states could always sue the federal government. And the court cautioned against that result in United States versus Texas, footnote 3 of that decision.
Okay. How about a doctor who opposes abortion? So she's on duty in an emergency room when a woman comes in with complications from having taken Mifepristone, and the doctor's the only one there on duty who can attend to this woman's problem, and as a result, in order to save her life, the doctor has to abort a viable fetus. Now, would that doctor then have standing to seek injunctive relief, or would you say that's too speculative? This was like being struck by lightning, and there's no, it's not sufficiently likely that this is going to happen to this doctor again.
We would agree that that would represent past harm, so we're not disputing that that kind of conscience violation, providing care in violation of one's conscience, would be cognizable. But yes, we think that that situation has never come to pass. Respondents haven't identified any incident in more than 20 years that Mifepristone has been available on the market that resembles that kind of hypothetical situation. And so, yes, our view would be it's unduly speculative. And you have to think about all of the events that would have to transpire to get to that moment in time.
I understand the argument. Now, how about a woman who suffers adverse consequences from having taken Mifepristone? Would she be able to sue for damages, or you would say that's barred by sovereign immunity?
I expect that we would have sovereign immunity arguments in that kind of case. I recognize that with respect to traceability, that's a harder argument for us.
Okay. Is there anybody who can sue and get a judicial ruling on whether what FDA did was lawful? And maybe what they did was perfectly lawful. But shouldn't somebody be able to challenge that in court? Who, in your view? Who would have standing to bring that suit?
I think that with respect to these regulatory changes, it's hard to identify anyone who would have standing to sue, but the court has said time and again that the fact that no one would have standing doesn't provide a basis to depart from Article 3 principles.
She's right.
It said that in Raines, in Richardson, in Valley Ford, and in Clapper. And so I think it's clear that even if there is no alternative person here who could sue, that doesn't mean that the court should dispense with the indispensable requirements of Article 3.
She's absolutely right on the case law. She's 100% right. It's like, if no one can sue, no one can sue. Right? So yeah, that's the right answer. If no one can sue, no one can sue. So maybe there is no one who can sue. So, yeah. Maybe that's the right answer. And she's absolutely right on the case law. So far, she seems to be crushing it pretty hard.
Okay, I understand that, and Article 3 is important. So your argument is that it doesn't matter if FDA flagrantly violated the law, didn't do what it should have done, endangered the health of women. It's just too bad nobody can sue in court.
Certainly we think that
there's no remedy. The American people have no remedy for that.
Well, I think that it would be wrong to suggest that if FDA had made a mistake and a drug were actually producing safety consequences, that there would be nothing to be done. I don't think that these respondents could invoke Article 3 jurisdiction to have the court step in, but FDA takes very seriously its responsibility to ensure the safety of drugs. It conducts ongoing surveillance and can make adjustments to the regulatory regime if safety situations emerge. The drug sponsors themselves remain responsible at all times. We have a tort system in this country, and that can help ensure that if there are safety problems that come to pass, the sponsors will take action in reaction to that. So if the premise here is that unsafe drugs could somehow remain on the market, I think that that's incorrect.
And so your argument here is, and as I said, I have great respect for Article 3. We all do. We have to comply with it. But your argument here is that even if the FDA acted unlawfully, nobody can challenge that in court. And that's basically the argument you made last week, right? In the Murphy case, we shouldn't get to the question whether the White House and others violated the right to freedom of speech. We should just say, well, these plaintiffs can't bring suit, right?
We are looking at the specific respondents in this case and their theories of standing. We don't think they come within 100 miles of the kind of circumstances this court has previously identified of non-speculative harm that can create the kind of cognizable injury for forward-looking relief.
I like her style and I like her answers. She's taken a hard line, but she can defend it. Not from the least of reasons, from the Supreme Court's own precedent. And so Alito's basic exchange for the last, I don't even know, 3 minutes, whatever it's been a hot minute at this point. Alito's basically exchange isn't it kind of absurd that no one can sue? And she's like, but no one can sue, that's the law. And she's completely correct on the relevant case law. And she seems to be even right as a matter of fact on these cases. It's like the harms are way too speculative, right? The harms are way too theoretical. It's like maybe if you dream really hard, right? Maybe if you dream really hard, you can find a way that some doctor somewhere would be harmed in some hypothetical. But as she points out, and we'll take her word for it, at least for the moment, no one in 20 years has actually faced this kind of situation, or at least one that's comparable. That's what she says. Like, they haven't identified, the other side hasn't identified anything in the last 20 years when this drug has actually been on the market where this kind of hypothetical has occurred. It's never happened. And even if she's wrong, even if it happened like once or twice, like, she could still make the argument, incidentally. Because, like, you know, it's just so unlikely. It's so speculative. You know, it's like, so these doctors aren't being harmed. No doctor anywhere has ever been harmed. And no one can bring suit. And that's the right answer. And that's just the way it goes. She knows the law, she knows the facts, and her presentation and organization is legendary.
I'm assuming that if there were if this had been unsafe in a grossly visible way, 40% more increased hospitalizations, that some doctor who was prescribing it would have challenged the lack of an in-person.
Well, no doctor is required, Justice Sotomayor, to dispense other than
No, but if a doctor who wants to, just like in a doctor who wants to do abortion, we have said if there's regulations that stop them from doing it, I guess that doctor could come in and say, this is unsafe. I can't, by not having people visit me beforehand, we're not warning them, et cetera, et cetera.
Certainly, I think if those kinds of distinct safety concerns emerge, there would be steps taken at the agency level. There's nothing like that here. There's no contrary evidence to suggest it.
I'm pondering a hypothetical.
But I do want to be clear that FDA's regulations here don't require doctors to not grant an in-person visit if they think that that is the best way to provide a standard of care here. So they are not directly required to dispense Mifepristone through any particular arrangement.
Counsel, can I ask you a question about the conscience injury? So that's one of the roadblocks you identify in the speculative chain, because you say a doctor could invoke federal conscience protections to refuse to complete an abortion that was when the embryo or fetus was still alive. So I just want to be clear, the federal government's position is that their doctor would have conscience objections. I'm thinking about the EMTALA litigation, and the Fifth Circuit criticized the government's inconsistent positions. But it is your position that such doctors would have recourse to the conscience protections of federal law?
Yes, absolutely. And let me be clear about this, because I think the Fifth Circuit did fundamentally misunderstand our arguments, and respondents have repeated that misunderstanding here. The federal government has never taken the position that EMTALA would override an individual doctor's conscience objections. We said
EMTALA is just a law that requires hospitals and other emergency providers to provide stabilizing care, regardless of ability to pay, because we don't want patients to, have to figure out what's going on in the moment. We want to save lives. So EMTALA is basically a law that, long story short, requires a hospital to stabilize a patient when they come in for care, regardless of ability to pay, regardless of anything else, right? You can't fund them off. You can't send them down the street unless, of course, that's necessary for the stabilization, right? Because you can't do it. You don't have the facilities. But, if you can do it, you must do it, right? You can't be like, oh, they're not insured, we don't want to, blah, 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 right? That is not an option. You must do it. It's the cost of doing business deal, right? And so what they're saying is, okay, look, there's a federal law that says you don't have to do the conscience breaking thing. And the doctors have at least tried to argue, at least according to the Solicitor General, the doctors have tried to argue, hey, we think this law that requires us to provide the emergency care overrides the law that says we don't have to do our thing that breaks our conscience. And the Solicitor General is now like, no, that's not true. That's not true. You do have to provide the stabilizing care. That is a general law. But there is an exception, because this is a more specific law. And the specific tends to overcome the general in any sort of legal framework, because, you have a general rule and then you have the specific, the exception. So it is perfectly consistent to read it that way, even to the extent that they're in conflict. You would read it that way as a matter of statutory interpretation, right? The general law is treat the person with the stabilizing care. That's the general law. The more specific law is you don't have to provide the care if it breaks your conscience. So she's like, okay, there's no conflict. The you must provide emergency care does not require the doctor to do these things. We do not take that position. We disclaim the position. So you're not required to do the conscience breaking thing. And because you're not required to do the conscience breaking thing, you no longer have standing, right? Because it's like, oh, you're making us, right? Because if the FDA was making them, or the federal government for that matter, if the federal government was making them, then they'd have standing, right? It's like, you must prescribe the medication. It's like, I don't want to, but you have to, just by the same way if the state medical board was doing it. The analysis would be different, obviously, but it's the same idea, right? If the federal government or the FDA or your state medical board or whomever is a governmental official in this hypothetical, if the government's like, you must do the thing, and you're like, but I don't wanna, and like, you must, or you're going to lose your license or whatever. Hey, it sounds like you have standing now because the government is making you do a thing. It sounds like you have standing now, and so it's like, okay, yeah, I'm going to go sue the government because they're making me do a thing. But Solicitor General just made very clear, we are not making you do a thing. We are not making you do the thing. You don't have to do the thing. You misunderstand our position. We're not making you do the thing. So you have no standing because we're not making you. So great. Excellent.
Exactly the opposite. If you go and look at our Fifth Circuit reply brief in the Texas litigation, we disclaimed that understanding of EMTALA and made clear that we understand the conscience protections to continue to apply and shield the doctor who doesn't want to provide care in violation of those protections.
Would that be true in a healthcare desert as well?
Yes. So we don't think that EMTALA would override conscience protections for the individual doctor. It, of course, imposes obligations on hospitals, and hospitals have all kinds of plans in place to address these types of contingencies. They have staffing plans. I understand as a matter of best practices, they often ask for doctors to articulate their conscience objections in advance so they can take account of that in staffing. They have cross-staffing agreements with other hospitals. And in the government's experience enforcing EMTALA, this is almost 4 decades of experience, we are not aware of any situation where there has been that kind of direct conflict between EMTALA and conscience protection.
Again, the U.S. government attempts to argue this has never happened. That's what the Solicitor General just said. The Solicitor General said there's never been a problem ever. The EMTALA has been the law for 4 years. The patient comes in. They're in need of care. You can't kick them. The pregnant woman comes in, she's in labor or whatever. It doesn't really matter what the patient is in for. We don't really care. The patient needs care. They need stabilizing care of some version. The patient is in the process of giving birth, would require stabilizing care, for example, or whatever. It doesn't matter. The patient comes in, needs stabilizing care of some variety. Hey, you hospital, congratulations. You know how how you're doing business in interstate commerce? Congratulations. One of the things you're required to do is take any patient who comes in the door and provide them stabilizing care. You have to get them stable. You can't kick them out. And if you can't do the stabilizing care, then you have to make sure they get somewhere to do stabilizing care. But you can't just kick them out because you don't want to. You can't just kick them out, blah, blah, blah. You can't do that, right? But there is a federal law that specifically says, hey, doctor, you don't have to do the thing that breaks your conscience, right? So it says, hey, hospital, you must provide care. But hey, doctor, you don't have to do the thing that breaks your conscience. So first of all, there's not necessarily a conflict between the two, because one's directed to the hospital and one's directed to the doctor. The doctor's like, I don't want to do the thing. And the hospital's like, okay, fine, we'll make sure someone else does the thing. Because it's a burden to the hospital, not to the doctor. And she says, well, in 4 decades, we've never had a case where there's a conflict, right? We've never had a case where, it's some remote hospital somewhere and it's the only doctor on staff and it's a one doctor hospital somewhere, right? It's the only doctor for 100 miles. It's a very strange hospital, but never mind. It's a one doctor hospital somewhere. We've never had the situation where there's basically no distinction between the hospital and the doctor, and we've never had the situation in 4 decades. So it's, again, too speculative. It's too speculative. If it ever comes up, we'll deal with it then, but you can't just speculate it into existence. She's kicking ass.
Okay, just one last question. This is about the association standing. So its own standing in its own right. I'm talking about not its standing that is based on an injury to one of its members. So the injuries that the association is arguing sound in the Havens Realty associational standing, and they're the kinds of allegations we see by immigration advocacy groups. Diversion of resources, increased expenses that result from the complications of having to address and explain the new changes. And I'm not talking about the expenses of filing the petition. That's not what I'm talking about. Let's just talk about the diversion of resources. Can you distinguish that from Havens Realty?
Yes. So I think Havens itself was trying to distinguish between 2 types of potential organizational injuries. And what Havens said is that in that case, the organization had come forward with direct and concrete demonstrable injury to itself. And there, the organization had a contract to provide low-income housing or a search to secure it for clients, and the racial steering practices directly interfered with that, made it more difficult for the organization to carry out its contractual obligations. But Havens itself said that it was not blessing a theory of standing that would allow an organization to assert a setback to its abstract social interests. So I think that reflects the court trying to distinguish between more concrete, direct, demonstrable harms on the one hand and that kind of abstract setback on the other hand. And I recognize, and your question touches on it, Justice Barrett, that some lower courts in particular have seemed to read Havens to endorse far broader theories of standing, including in the immigration context. The government has been routinely resisting standing because we think that would essentially mean that any advocacy organization could say it opposes what the federal government is doing and so therefore has to devote resources to that opposition. If that were enough, then every organization would have standing, and it would be a vast expansion of ordinary Article 3 principles. So we would welcome an eventual clarification from this court on organizational standing, but here I think that the organization's assertion of injury falls in the bucket of the abstract setback and doesn't come close to the kind of demonstrable harm that was at issue in Havens.
I love it. I love it. So she basically takes a moment to swipe at the Supreme Court on its own organizational standing problems, right? So that's what this is all about. We're talking about organizational standing. And one of the classic bases to say an organization has standing is this idea of diversion of resources. But for the federal law, we wouldn't have to expend money in this way. So we're diverting resources. So that's a basis on which organizations in the past have had standing. So she says, first of all, in the prior case, they say the organization came forward with direct and concrete demonstrable injury to itself. And so she says the court's been trying to distinguish between concrete direct harm and the kind of abstract harm. And she then points out that Justice Barrett's question basically exposes a weakness in organizational standing doctrine in a sort of global way. Because it's like, well, you know, if the issue is diversion of resources, if that is the issue that gives you standing, then all you need to do is come up with an organization that says we oppose the federal law, whatever it happens to be. It doesn't really matter. And obviously they're spending money to fight the federal law. And now they're expending resources to fight the federal law. So you basically bootstrap your way into standing with nothing else, right? It doesn't matter. What is something that could never even hypothetically apply to me? What's some federal law that could never even hypothetically apply to me? Revocation of citizenship. There you go, because that's not possible for an American citizen. Forced revocation, because I can revoke my own citizenship by, you know, going overseas and disclaiming it. But the federal government can't take citizenship away from me. There's a Supreme Court about that, right? So, okay, what circumstances can you take away someone's citizenship? Well, you know, they were naturalized and they lied in their applications, basically the long and short, right? So I started an organization whose mission in life is, you know what? We don't think that even under that circumstance, you should revoke citizenship. It should be a one and done thing. You know, once a citizen, always a citizen is what I say, right? And so I'm going to start a non-for-profit whose entire mission in life is that we oppose the idea of the ability, even theoretically, to take away citizenship for anyone. It's like, this could never apply to me personally, because I'm a U.S. citizen by birth. It could never apply to me. But I've started an organization that's now its sole purpose in life. So if I bootstrapped my way into standing on this thing by creating an organization whose entire purpose is to oppose the thing that I myself could never apply to. It's like, this is a very strange idea that I could bootstrap myself into standing. Because if I can do that, right, if I can bootstrap myself into standing on that issue, then I can bootstrap myself into standing on every issue, right? All I have to do is create an organization that opposes whatever federal law it is I want to oppose, and that instantly grants me standing. So she takes a swipe at the U.S. Supreme Court and basically says your own standing doctrine has a hole in it. Nice. That's ballsy. Nice. She takes the time to basically chastise standing doctrine writ large. Just as an aside, as long as I'm here, your standing doctrine needs work. Pretty ballsy.
General, I'm sorry.
I'm done.
Okay. That's a helpful clarification. I'd like a similar clarification. Thank you. With respect to individuals, I've heard and listened to your argument and read the briefs, and I think I understand it. But how does it fit in your mind with offended observers standing under the Establishment Clause, or some injuries about I access a park and I like to look at it in a certain way, and those kinds of injuries that the court has sometimes recognized and other times cast doubt on?
So it's true. I think that there are different strands of this court's precedent, and I would put the Establishment Clause precedent and First Amendment precedent generally in its own bucket, because the court has sometimes recognized different theories in the First Amendment context.
Back on that a little bit, because standing is standing. It's Article 3,
yes,
right, that we're interpreting here. And so I think we've got to find some way to stitch it all together, and I'm looking for guidance from you.
So I think the way to approach this is to, if you're going to recognize some kind of offense or distress type of injury, that to recognize that there
Should
has...
we?
Well,
no,
I mean, I represent the government, so I think that kind of theory of injury would likely go far too much in the direction of allowing Article 3 courts to weigh in based on generalized grievances. But I guess what I would say is to distinguish the cases where this court has sometimes found that type of injury cognizable. Generally, it's in a situation where there is a kind of direct governmental action producing that type of injury. And here, our argument is that the FDA's actions in approving Mifepristone, specifically in 2016 and 2021, if you're looking at that, which was an incremental change, is so far upstream of the downstream assertion of harm or distress that the respondents are asserting that there is, just as a matter of law, an attenuated link here that cannot suffice for Article 3 jurisdiction.
She's got a pretty solid point.
Thank you.
Thank you, counsel. Justice Thomas, anything further? Justice Alito?
Oh, you say that the Fifth Circuit didn't give any reason to think that the three changes made, and they're all done together. And why shouldn't the FDA have addressed that?
I think the only way that that would be true would be if the three changes are interconnected and mutually reinforcing, guarding against the same kind of safety risk. So I agree that if there were reason to think that the reason why Mifepristone is safe up to 10 weeks gestation is because it's being prescribed by doctors instead of nurse practitioners, for example, then those changes would be interconnected because one change would effectively be the safety net for another. But there was nothing like that in this record. The studies that FDA examined instead demonstrated that these changes, and it was an exhaustive examination, were safe not because there were other different safeguards in place to guard against risks, but rather because if you go up to 10 weeks of gestation, there is no observable increase in serious adverse events, no matter who's prescribing. So in the absence of that kind of correlative effect of the changes, I don't think you can fault the agency for not giving even more explicit attention to this issue. And it did. It cited multiple studies that
Why does Preligar argue every case? She's the Solicitor General of the United States. It's her prerogative. She's the lawyer. She's the Solicitor General. That's her job. And why she argues so many of them personally, I couldn't really say. But it's her prerogative. I mean, it's her job. So she wants to argue more of them personally. Okay. I mean, you know, all right, fair enough. That's the way she wants, because she wants to, basically, is the answer to the question.
Combined multiple changes precisely because the standard of care had evolved over the 15 years Mifepristone had been approved, and many of the changes were already being deployed together safely.
Shouldn't the FDA have at least considered the application of 18 U.S.C. 1461?
So I think that the Comstock provisions don't fall within FDA's lane.
Comstock, not Volstead Act. Volstead Act was alcohol. I knew it was wrong the moment I said it, because I said it was a violation of the Volstead Act. And the moment I said it, I'm like, Volstead Act applied to alcohol. Did the Volstead Act also apply to abortion pill? Was it both? No, it wasn't both, Kurt. It was called the Comstock Act, not the Volstead Act. So, yes, thank you for correcting me, Solicitor General. Not the Volstead Act, which prohibited the sale of alcohol. The Comstock Act, which prohibited the mailing of abortion medication. Thank you for that clarification.
FDA under the FDCA can only maintain restrictions under the REMS program if it's necessary to ensure safe use. In 2021, what FDA determined is you don't need in-person dispensing for safe use, so the FDCA did not independently require that REMS restriction, and in fact it couldn't be imposed once FDA had made that determination. Now that doesn't affect other sources of law. FDA was not affirmatively approving mailing in violation of Comstock, even if you interpreted it that way, and we don't think it means what respondents suggest it means. But at the very least, I don't think that it was FDA's responsibility to consider that, nor could it have permissively considered that under the statute.
Well, it didn't say any of that. It didn't say anything about it. And this is a prominent provision. It's not some obscure subsection of a complicated, obscure law. They knew about it. Everybody in this field knew about it. Shouldn't they have at least addressed it? You have answers to the arguments that are made on the other side. Shouldn't the FDA have at least...
are safety and efficacy concerns in deciding whether to maintain.
Yeah, the sync is just getting worse and worse, by the way. The sync is done by our good friends at oyez.org. So I didn't create the sync. I can't fix the sync. The sync is embedded. I suppose I could try to like do it manually and keep it like on screen vaguely where it's at. I'll try to keep it vaguely on screen because the sync is getting worse and worse. I'll try, but the problem is it automatically resyncs it every time. I'll do my best, but it's going to be rough. So, yeah, just bear with us.
Maintain a REMS program. But the other thing I would say, Justice Alito, is that the agency did have a memorandum on Comstock. It's at JA 535. That was the advice that FDA received from OLC conveying the interpretation of Comstock.
But it got the advice from OLC, but it didn't refer to that, did it?
In the 2021 decision, no, but the REMS was then modified in 2023, and this was part of the administrative record for that.
Okay, one last question. The plaintiffs say that the studies that the FDA relied on for the 2021 amendment say that mail order Mifepristone suggests more frequent trips to the emergency room. Now, this is what I see as the FDA's response to that. Quote, although the literature suggests there may be more frequent emergency room care visits related to the use of mifepristone when dispensed by mail from the clinic, there are no apparent increases in other serious adverse events related to mifepristone use. Does that really count as a reasoned explanation to the suggestion that the data shows there are going to be more emergency room visits? This is the increase in emergency room visits is just of no consequence. It doesn't even merit some comment.
That is a reasoned explanation. What FDA was observing in that passage is that although it acknowledged the fact that some of the studies reported additional emergency room visits, that didn't equate to additional serious adverse events. And in fact, one of the studies, half of the women who went to the emergency room didn't get any treatment at all. Many women might go because they're experiencing heavy bleeding, which mimics a miscarriage, and they might just need to know whether or not they're having a complication. But in that kind of circumstance, the woman is not having a serious adverse event from mifepristone, and so it doesn't call into question the safety determinations regarding the drug. And at the end of the day, FDA carefully parsed those studies. It made specific determinations about the results to be gleaned with respect to safety and efficacy. It fully explained its decision-making, and I think it falls well within the zone of reasonableness under arbitrary and capricious review.
All right, thank you. Justice Sotomayor?
On that last question, because that did trouble me, but the reality is, even if there is some increase in emergency room visits, the question of when that rises to a sufficient safety risk is up to the FDA, correct?
That's right. And, FDA acknowledged it, so it's not like it overlooked this aspect of the studies. I also want to emphasize, Justice Sotomayor, that the studies were far from the only evidence FDA consulted. At the time it acted in 2021, it had real-world experience during the COVID-19 pandemic, a period of time when the in-person dispensing requirement was not enforced, and FDA started by looking at, as a comparative analysis, the two periods of time when you had in-person dispensing and when you didn't, and saw that there was no relevant increase in serious adverse events or difference between those two time frames. So that further supported the safety conclusion.
The problem with all drugs is there are complications in virtually all of them.
Yes,
and at what level the cost-benefit analysis tells you to stop prescribing something is a very difficult question, isn't it?
And that's a question that Congress has entrusted to FDA.
But putting that aside, here, whatever the statistical increase was, FDA determined under the REMS standard that it wasn't sufficient to create a risk that counterbalanced the need for access, correct?
Correct, because FDA is instructed to take into account burdens on the healthcare delivery system as well, and it looked at a variety of sources of data to conclude that on balance, the burdens were suggested that it was not necessary to keep this restriction in place to ensure safe use.
Thank you.
Justice Kagan?
General, if I could take you back to the discussion that you were having with Justice Barrett about the conscience objection, and just ask you, I'm sure that you've read the declarations carefully, and I'm sure Ms. Hawley will have things to say about this too. But as you read those declarations, what is the conscience objection? What are the doctors objecting to exactly?
I think the declarations are specific on this point. There are only 7 doctors who regularly practice and submitted evidence, and the declarations are relatively short. This is at JA 150 to 200. I encourage reading them because there are only 2 doctors out of the 7 who even provide any information about their specific conscience objections.
Those 2 are who?
Those are Dr. Skop and Dr. Francis. The relevant language for
the other 5 don't refer to conscience objections.
They don't refer to their own conscience objections or provide any specific detail about exactly what care would violate their conscience. Dr. Francis is at JA 155. Dr. Skop is at JA 167. Both describe the injury.
How does she know that? I mean, that's just like, how does she know exactly what page it's on? That's just, I mean, I appreciate that she knows the range of the thing, and I appreciate she knows the name. But she knows exactly what page it starts on? How does she know that? How does she know exactly what...
in the the same terms. They object to ending the life of a human being in the womb and fear that they might have to complete an abortion for a woman who has an ongoing pregnancy.
So as you understand those declarations, they do not object to providing whatever care is necessary to a person who may have complications from taking mifepristone. In other words, for example, suppose somebody has bled significantly, needs a transfusion, or any of a number of other things that might happen. As you understand the declarations, there's not an objection to that.
I think that the fairest reading of the declarations is they are not objecting to that. Now, I acknowledge that respondents in their red brief have suggested there's a broader conscience injury in play here and that there might be other doctors who have a broader concern about providing any care. Even if that broader conscience injury had been in this declaration, we think still as a matter of law they could not demonstrate that they have a non-speculative injury, in part because of all of the upstream things that would have to happen in terms of a woman having the serious event, going to these specific doctors, but also the fact that federal conscience protections are specifically designed to deal with this issue, and they would cover the range of conscience objections that exist in this context.
Right. There are obviously conscience objections of all kinds. I was just asking about the particular declarations of these particular members of the organizations.
Yes, and I think on these declarations they have not asserted a broader injury, but even if they could conceivably come forward with other doctors or try to adjust their declarations in some way, still that would not suffice.
Okay.
Nice.
Can I just ask a quick question about the merits? You open your brief with a somewhat arresting statement, but it starts with "to the government's knowledge," and this was written a few months ago, and since then I'm sure that you've had lots of time to think about this case and to get all background information on it. So I'll just read you this sentence and ask you whether it's still true. To the government's knowledge. To the government's knowledge, this case marks the first time, and I'm going to say, is it the first time? Is it the only time? Any court has restricted access to an FDA-approved drug by second-guessing FDA's expert judgment about the conditions required to assure that drug's safe use. Is it still the only time?
That is still, to our knowledge, the only time a court has done that. We have seen a disturbing trend of courts sometimes also overriding FDA's judgment to try to grant greater access to drugs when that overrides FDA's expert judgment about what's necessary to ensure safe use. And no matter which direction you come at it from, we, on behalf of FDA, think that courts have no business making those judgments in the absence of the kind of arbitrary and capricious error that would satisfy the APA.
Nice.
Thank you.
Justice Gorsuch, Justice Kavanaugh.
Just to confirm on the standing issue, under federal law, no doctors can be forced against their consciences to perform or assist in an abortion, correct?
Yes, we think that federal conscience protections provide broad coverage here. Just to be super precise, there are some triggering requirements of receiving federal funding and so forth. We've cited the relevant provisions at page 5 of our reply brief. The church amendments have the most comprehensive protection here, and we think that those amendments guard against the kind of injury that respondents are asserting. There are also state law protections that often apply in this context.
Thank you.
Justice Barrett?
Would that be true even if the declarations were interpreted as respondents do, to say that they regard any participation, even transfusions or DNCs, after the abortion is otherwise complete because tissue needs to be removed?
Yes, I think that would be true. So the most relevant church amendment provision is 42 U.S.C. 300A-7D, and its language says that a doctor shall not be required to perform or assist in any part of the healthcare program that would violate the doctor's religious or moral beliefs. So it's tied to the nature of the doctor's beliefs rather than particular procedures.
And one other question, and this goes to the merits. As I understand it, the serious adverse consequences that have to be reported or that FDA considers risks are death and transfusion, but not, say, I mean, it seems to me, and I think the data bears this out, that the elimination of the in-person dispensing requirement or, the in-person visit at the outset would lead to mistakes in gestational aging, which could increase the need for a DNC or the amount of bleeding, et cetera. But that does not count, correct, as an adverse event?
So I want to be careful because there's a list of serious adverse events, and I'm not sure that I have all of them down to be able to recite them to you, although they're in the record. But I do think the premise of the question is wrong, this idea that the change to in-person dispensing would necessarily increase the risk of those events. That was not reflected in the data that FDA consulted, and I would point you to JA 383 to 384 in particular, where FDA explained that even in person, you're not necessarily getting an ultrasound. That's never been required. And so the relevant question might be, is your provider going to ask you a series of screening questions, like when was your last menstrual period, in person or via telemedicine? And there's no evident reason why that difference would actually lead to different safety outcomes.
So there was not even I thought that there was a small percentage increase in the tracking. I'm wrong about that, which I may well be. You know the JA way better than I do.
Yeah, so I think that with respect to the ER visits, there was some evidence that there were increased ER visits, although as I explained to Justice Alito, that wasn't actually correlated with an increase in serious adverse events. You know, I don't want to represent all of the different findings of the different studies because they varied a little bit, but FDA's ultimate conclusion was that Mifepristone could safely be dispensed without in-person visits. It had voluminous evidence, I think, to support that conclusion in 2021, and there's been no contrary evidence that's been introduced.
So there was no requirement of either an ultrasound or detecting a fetal heartbeat or anything like that, even before the doctor could just go based on the woman's recounting when her last menstrual period was.
That's right, and that dates all the way back to the initial approval of this drug in 2000. It has never been a required condition of use to have an ultrasound. FDA has always left that up to medical judgment. Now, it is of course necessary for providers to be able to diagnose ectopic pregnancy and to date gestational age. That remains true under the REMS now. Prescribers still have to have that capability, and they have to deploy whatever mechanisms they believe would accurately allow them to identify contraindications for use of Mifepristone. But it's wrong to suggest that if the court reverses 2021 changes, then every woman's going to get an ultrasound. That's never been the state of play in how this drug has been administered.
How, even under the pre-2021 REMS, was it possible to detect an ectopic pregnancy without an ultrasound unless the woman was presenting with pain?
So there's a set of screening questions that are often deployed. You can ask things like, do you have unilateral pelvic pain? Did you become pregnant while you had an IUD in or after a tubal ligation? Are you experiencing unusual bleeding? You can ask whether the woman has had a prior ectopic pregnancy. And if the woman has those kinds of risk factors, then imaging may be necessary. But that remains true under the 2021 REMS as well. The prescriber has to be confident that it has excluded those kinds of conditions before prescribing this drug. And the standard of care around the world, most medication abortion occurs without an ultrasound. Thanks.
Justice Jackson.
Good morning, General. So I'm worried that there is a significant mismatch in this case between the claimed injury and the remedy that's being sought, and that might or should matter for standing purposes. I don't know that our doctrines sort of capture this, but I guess I see it that the injuries that the respondents allege, as you've articulated them, are a conscience injury, that they are being forced to participate in a medical procedure that they object to. And so the obvious common sense remedy would be to provide them with an exemption, that they don't have to participate in this procedure. And you say, and you've said here several times, that federal law already gives them that. So I guess then what they're asking for in this lawsuit is more than that. They're saying, because we object to having to be forced to participate in this procedure, we're seeking an order preventing anyone from having access to these drugs at all. And I guess I'm just trying to understand how they could possibly be entitled to that, given the injury that they have alleged.
I agree, Justice Jackson, and I do think it's relevant to standing. There's a profound mismatch here between the claimed injury and the remedy they were seeking. And, you know, you can almost think of this as a type of zone of interest kind of analysis. You know, if the doctors have a conscience injury, there's a specific statute designed to deal with it, to specifically tailor-made guard against the risk of that injury occurring. And instead, they're reaching out and seeking to invoke rights under a different statute, the FDCA, that doesn't regulate them at all, that doesn't make them do or not not do anything, and the relief that they're seeking would dramatically alter the approved conditions of use for mifepristone and affect women all around the nation simply because of this conscience injury that's already directly addressed by other protections.
Right, and if it wasn't addressed, then we would see this lawsuit, and the remedy would be to exempt them, right?
Yes. I think that one of the hard things about trying to tailor relief here is that they're asserting such a diffuse theory of injury that it's almost as though the only option was to grant a nationwide remedy of the kind the lower courts issued, and that runs counter to ordinary Article III principles of party-specific relief. But I just think it shows that there's something wrong with the theory of injury in the first place because it's so attenuated and because they claim they would need so much relief all over the country.
Let me ask you another question. In addition to the challenges that we have here, the respondents below challenged the FDA's initial decision to approve mifepristone in the year 2000. Of course, that occurred a very long time ago. The Fifth Circuit found that challenge wasn't timely because of the statute of limitations. As you're aware, in the context of another case we heard this term, the court is currently considering the statute of limitations issue. So setting aside standing, have you thought about how a ruling from this court on the statute of limitations in either direction might impact what happens in these kinds of cases with the
Let me read this question because I'm so on the statute of limitations issue. Okay. Yeah. All right. Let's see what she says.
These kinds of challenges.
Yes, I think that it just reflects the stakes of the corner post case and provides a vivid example of the way that it might be possible if this court were to approve the request for a broader theory of the statute of limitations in that case, the way it could open the door to plaintiffs coming in and saying, well, I only became a doctor later, or I only started working in an emergency room later, and would try to unsettle longstanding agency actions that maybe occurred decades previously. I do want to say that I understand the corner post petitioner to have suggested maybe there would be equitable defenses that the government could raise in those kinds of cases. We would certainly want to raise that type of defense with respect to the approval of mifepristone, which I think has generated tremendous reliance interests and proven to be safe and effective over decades of use.
Thank you.
Thank you, counsel. Ms. Ellsworth?
Well, the genius of Solicitor General Prelagar continues to manifest. She is as good at this as anyone I've seen, and maybe better than at this than anyone right now. She has, in recent memory, outshone even the greats from time to time. So she may be the best. She's smart, and she has her talent really comes in her framing and her ability to maintain frame. Which is incredibly challenging. It's like, how do you create the frame so that everything falls within your frame, and they keep trying to attack her frame, and it just doesn't work. The attacks on the frame just don't work. Sure, her ability to set up a frame and maintain frame is just like legendary. And she doesn't get flustered, she doesn't get bothered, she doesn't get upset, she doesn't get riled up. She just deflects. She just constantly deflects in a way that doesn't come off as, she deflects in a way that doesn't seem like she's avoiding something. She just deflects in a way that makes it seem like she's the smartest one in the room. It's like, my answer is smarter than your question a lot of the time. So the Solicitor General continues to impress. The Solicitor General's argument basically boils down to, in so many words, first of all, that we don't think they have standing, because how have they been harmed? It's a pretty good question. How have you been harmed? It's always a pretty good question. And it's like, can anyone bring standing? And she's like, not that I can see. And even if that's true, it doesn't mean that, you should defy standard standing rules. The Supreme Court said that before a couple times. She's completely right. So yeah, we can't think of anyone who is standing, but that's okay. That's just the way it goes, because no one has standing. No one's been harmed by this. And anyone who has been harmed is like, there's no evidence of harm, even in the past, in any way you slice it. And then she even defends the FDA on the merits of the thing. So she goes past standing, and she even answers on the merits, and is like, yeah, they've looked at everything. They looked at everything. And they acknowledged there were risks, and they acknowledged there were problems, and they acknowledged the things they're supposed to acknowledge, and they made it a calculus that, you know, hasn't seemed like completely ridiculous. It's not been proven to be arbitrary and capricious, so on the merits, it should be good. And the only thing she sort of has the only real problem that they have is the mailing thing, because I think Justice Alito correctly pointed out under the Comstock Act that there is a problem under the mailing. But then again, who can object to this? Who can object to the thing that's happening? It's like the law says you're not allowed to do it, but who can raise the issue? And it's like, yeah, it's a pretty reasonable argument. So Solicitor General continues to slay in every possible way. So, okay, so we are next going to hear from the petitioner. Okay, so we're going to hear from another petitioner, Danko Laboratories LLC. So this was consolidated. So this is two cases for the price of one, I think. So we're also going to hear from a petitioner for Danko Laboratories LLC. I assume the petitioner from the companion case, who has been given time in this case because they were consolidated. So we'll hear some more arguments in favor of this before we hear arguments against. In my dreams, I'm not as good as Preligar. Her ability to set and maintain frame, I don't know where she gets that from. It must be natural talent. The real thing is that she does it without seeming arrogance. She does it without, at least in my humble opinion, she sets and maintains frame without seeming absurd or arrogance or like she's disingenuously deflecting or things. Like she dodges laser beams just constantly. And so she's able to maintain frame and not seem arrogant or ill-informed. She knows it. She knows the damn page numbers that thing starts on. I mean, you know, I don't know how you get to be this good. I mean, if she only had one case, maybe, right? Maybe she only had one case, maybe. But the fact that she has so many cases because she's the Solicitor General, and she apparently likes to do them herself rather than farming it out to someone else in her office, and she knows all these cases and all these records this cold, it's like, how are you able to maintain that much information in your head? She makes me look like the most rank amateur in the history of time, man. All right, let's see what Erin Hallway has to say on the subject. Let's get started with this.
Emergency room. And 3, the FDA acknowledges that women are disease that between 2.9 and 4 points under which millions of women used abortion.
Not in the administrative record and would never be review process to
How far back do I have to go to find out where this thing starts?
So it is.
Oh wait, I wasn't even in the right place. Sorry.
Medic Act is limited to.
Still have to go further back.
Is not an academic.
Nope.
Could be called someday.
Nope.
Mifepristone, which I think has generated tremendous reliance interests and proven to be safe and effective over decades of use.
Thank you.
Thank you, counsel. Ms. Ellsworth.
Mr. Chief Justice, and may it please the court. In 2016 and 2021, FDA made certain changes to the labeling and use restrictions for Danko's drug Mifepristone. The decision below stops Danko from selling Mifepristone in line with that scientific judgment based on a highly attenuated claim that an unknown doctor could be called someday to an unknown emergency room after a series of decisions by third parties. No facts causally link that possible future encounter to a specific change FDA made in 2016 or 2021. Respondents' view of the Food, Drug, and Cosmetic Act is so inflexible it would upend not just Mifepristone, but virtually every drug approval and REMS modification FDA has made for decades. Reversal is required for two reasons. First, Article 3 standing is not an academic exercise in what's conceivable. Respondents lack standing under every prong of the analysis. Second, on the merits, FDA exhaustively considered the evidence and reasonably explained its conclusions, which is what is required to do. I welcome the Court's questions.
The government, the Solicitor General points out, would not be susceptible to a Comstock Act problem. But in your case, you would be. So how do you respond to an argument that mailing your product and advertising it would violate the Comstock Act?
Justice Thomas, we agree very much with the government that FDA's charge under the Food, Drug, and Cosmetic Act is limited to looking at safety and efficacy considerations. That's true for new drug approvals. It's also true for REMS modifications. FDA routinely approves drugs whose manufacture and distribution is restricted by other laws, like the Controlled Substances Act, environmental laws, customs laws, and so on. I think this Court should think hard about the mischief it would invite if it allowed agencies to start taking action based on statutory responsibilities that Congress has assigned to other agencies. On the merits, this issue was not presented below, was not ruled on below, and in any event, I would also point out that in 2021, FDA's decision allows use of brick-and-mortar pharmacies in addition to mail-order pharmacies.
Well, my problem is that you're private. The government, I understand the government's argument, but you're private, and the statute doesn't have the sort of safe harbor that you're suggesting. And it's fairly broad, and it specifically covers drugs such as yours.
Your Honor, we disagree that that's the correct interpretation of the statute, but we think that in order to address the correct interpretation, there would need to be a situation in which that issue is actually teed up. This statute has not been enforced for nearly 100 years, and I don't believe that this case presents an opportunity for this Court to opine on the reach of the statute.
Counsel, I'd like to ask you the same questions I was posing to the Solicitor General. You know, our precedents, Clapper and Susan B. Anthony list, talk about requiring a substantial risk that harm will recur, and you argue that's not present here. How are we supposed to find the spot at which the risk becomes substantial?
Your Honor, I think this Court has always thought about these standing inquiries as really a question of degree, and you're trying to evaluate whether something is actual and imminent or whether it's conjectural and hypothetical. And these terms, substantial risk, certainly impending, which has been used dating all the way back to 1923, get at where a claim falls in this spectrum.
Right. I mean, we toss around a lot of adjectives, but I'm just trying as a practical matter, how do you figure out? I mean, what percentage of adverse consequences would be enough? What percentage of emergency room visits would be enough?
I think the way Clapper got at that question, and you can see this in footnote 5 of the opinion, is to really think about whether there is an attenuated chain of contingencies that have to happen. And in situations where there is this kind of attenuated chain of circumstances involving third-party decisions that have to play out in a particular way, and here that chain is quite long, that squarely puts a plaintiff's theory on the side of the conjectural or hypothetical and not the certainly impending injury.
How is your company aggrieved by the challenge that is brought in this case? I gather this is your version of Mifepristone is the only product you are currently marketing. Is that right?
That's correct, Justice Alito.
And the Fifth Circuit decision does not prohibit you from continuing to produce and sell that product, right?
That is correct.
All right. And so I gather your injury is that you think you're going to sell more if the restrictions that previously were in place were lifted.
Yes.
So you're going to make more money.
The injury is that we are prevented from selling our product in line with FDA's scientific judgment about the safe and efficacious use of the drug.
And you're going to be harmed because you're going to sell more.
I think that certainly a company's ability to market its product is a part of how it considers the regulatory scheme that governs its conduct.
During the questioning of the Solicitor General, the statement was made that no court has ever previously second-guessed the FDA's judgment about access to a drug, right? And it's never second-guessed that.
That's correct.
Do you think the FDA is infallible?
No, Your Honor. We don't think that at all, and we don't think that question is really teed up in any way in this case.
Has the FDA ever approved a drug and then pulled it after experience showed that it had a lot of really serious adverse consequences?
It has certainly done that, and Your Honor, I think that underscores why the adverse event reporting, the post-market surveillance that FDA does, the ability that these plaintiffs have, even if they don't have standing, certainly if they are seeing patients who are presenting with adverse events, if they are doing studies that show there is some unknown safety component that FDA should acknowledge, they can take significant steps to bring that to the agency's attention, to bring that to Danko's attention.
But don't you think the FDA should have continued to require reporting of non-fatal consequences?
Your Honor, the FDA decided not to continue that reporting requirement in 2016 based on more than 15 years of a well-established safety profile when that reporting was required. There is no drug on the market today under any REMS that requires the kind of reporting that the plaintiffs are saying should be reimposed here.
So why would that be a bad thing? Wouldn't your company, I mean, you don't want to sell a product that causes very serious harm to the people who take your product relying on your tests and the FDA's tests. Wouldn't you want that data?
Your Honor, that data is certainly something that we are looking for all the time. It is part of the reporting obligations for a manufacturer to be aware of any data that's becoming available through any means. We have a 1-800 number on our website. There's a 1-800 number on the labeling. I think Your Honor's question, though, gets at concern I heard in some of the earlier questioning about who would have standing if these plaintiffs don't have standing. And one of the things I want to note is that drug manufacturers are very frequently subject to tort litigation. Product liability suit, failure to warn suits, deceptive advertising suits when someone is claiming harm from a pharmaceutical manufacturer's product. What is so, I think, revolutionary really about the arguments here, both on standing and the merits, are the way that they attempt by individuals who do not use this product, do not prescribe this product, and have a conscience right not to treat anyone who has taken this product. Those individuals want to prevent anyone else from using it in line with FDA's considered scientific judgment.
Does your company, just one more point along the same lines, does your company think that what the FDA has done preempts state laws that prohibit the dispensation of Mifepristone within their borders?
We have not taken a position on that issue, and it has not been teed up in this case.
What is your company's position on it? You haven't even thought about it? One of your competitors made that argument, right?
That's right. There are some lawsuits that have been brought by the generic company that do make that argument, and I think that is for later courts to sort out. Our position in this case has been that this is about FDA's scientific judgments reached in 2016 and 2021.
So you don't want to answer that question?
I don't think we have a position that's on that I'm prepared to say today.
Could you go back?
Hell no. Something about that exchange just didn't seem good for her. I feel like Preligar would have been able to handle that exchange better. It's like it's hard to put your finger on exactly what she did wrong. It just, you get to the end and it's like it feels like an evasion. It feels like an unfair evasion. It feels like she's put to the question and she doesn't feel like it feels like she's evading. As opposed to Preligar, when she evades, it doesn't feel like she's evading. It feels like she's judoing the whole shit. She's redirecting the energy, and it's like, my answer is smarter than your question. So Prelagar would have been able to handle that with more of a judo move. And to her, it just looks, oh, like you're avoiding the thing. It's like, yeah, you don't have any thoughts about this. You haven't thought about it at all. It's like, there's nothing wrong with her answer. Her answer's fine. It's just, it's not what Prelagar would do. But then again, no one can do what Prelagar could do because Prelagar is not immortal.
We will hear argument this morning in case.
Shut up.
To Justice Alito's questions about adverse event reporting, and you said you were subject your product to higher standards, and now we're being brought down to the sort of regular. Could you talk about that a little bit? What are the normal standards for adverse event reporting as you understand them? Why are they there? What instead were you subject to in the past?
May I answer the question? Justice Kagan, what changed was not Danko's adverse event reporting responsibility. Danko's adverse event reporting responsibility has been the same throughout this period. What changed was that from 2000 until 2016, prescribers were obligated to report adverse events to Danko, and then Danko then had its separate reporting obligation to FDA. So in 2016, the REMS for Mifepristone were aligned to be more consistent with the reporting requirement that applies to all 20,000 plus FDA-approved drugs. There are only today 7 REMS that continue to have even the limited higher adverse event reporting for deaths that apply to Mifepristone. So it is only one of 7 that have that.
Thank you.
Justice Thomas? Justice Alito? Any further? Justice Sotomayor? Justice Kavanaugh? Justice Barrett? Justice Jackson? Anything
I just
further?
have one quick question. So you were asked if the agency is infallible, and I guess I'm wondering about the flip side, which is, do you think that courts have specialized scientific knowledge with respect to pharmaceuticals? And as a company that has pharmaceuticals, do you have concerns about judges parsing medical and scientific studies?
Okay. Justice Jackson, you might want to figure out a way to phrase the softball that makes it not so glaringly obvious. That is one of the less discreet softballs I've seen in a while. I mean, many softballs are not necessarily discreet, but this softball strikes me as just very blatant. It's right, you know, most people hide it better, and this one is not hidden at all. It's like, hey, do you have any concerns about the courts deciding these cases because they don't know anything about drugs? You want to answer that? I think you got to figure out a way to phrase this that makes it a little less obvious what you're doing. A little more subtlety would go a long way. Yeah.
23-235, the Food and Drug.
Yes, Your Honor. I think we have significant concerns about that, and there are 2 amicus briefs from the pharmaceutical industry that expand on why exactly that's so concerning for pharmaceutical companies who do depend on FDA's gold standard review process to approve their drugs and then to be able to sell their products in line with that considered judgment.
Can you say a little bit about what they say?
I'm happy to. I think the reality is, and this court is this decision below is a good example of it. You have a district court that, among other things, relied on one study that was an analysis of anonymous blog posts. You have another set of studies that he relied on that were not in the administrative record and would never be because they post-date the FDA decisions here. They have since been retracted for lack of scientific rigor and for misleading presentations of data. Those sorts of errors can infect judicial analyses precisely because judges are not, they are not experts in statistics. They are not experts in the methodology used for scientific studies for clinical trials. That is why FDA has many hundreds of pages of analysis in the record of what the scientific data showed, and courts are just not in a position to parse through and second guess that.
Thank you.
Thank you, counsel.
Yeah, I'm gonna again, I'm not necessarily opposed to a softball, but dude, it's like you're supposed to make it, it's usually a little more discretion in this, in the way you phrase it. The ideal is you want to do it in a way that's not blatantly just completely just be like, hey, you want to shit on the courts for a while and how they can't do this? And hey, some of your amicus said some things about how they don't like the courts either. You want to shit on the courts for a while? It's like, you gotta, this is much more on Jackson than the advocate. It's like, but Justice Jackson, you gotta find a way to make that a little less obvious. Man, come on.
Thank you.
Ms. Hawley?
Mr. Chief Justice, and may it please the court. FDA approved abortion by mail based on data it admitted was, quote, not adequate. That violates the APA. The lower court's decision merely restored long-standing and crucial protections under which millions of women used abortion drugs. We've heard a lot this morning about standing. Article 3 is satisfied here because 1, the FDA relies on OB hospitalists to care for women harmed by abortion drugs. 2, the FDA concedes that between 2.9 and 4.6% of women will end up in the emergency room. And 3, the FDA acknowledges that women are even more likely to need surgical intervention and other medical care without an in-person visit. According to Guttmacher, nearly 650,000 women take Mifepristone every single year. It's no surprise that respondents have experienced...
That's a lot. 650, is that really the number? 650,000 women take the abortion pill every single year? I mean, really? That's a lot. Okay, I mean, that's a lot. It has other uses too? Fair. Okay, so I suppose the next logical question is, I don't know if you know the answer to this, but what percentage of the uses are for other uses other than abortion? Does anyone happen to know that off the top of their head? Like, if for all the prescriptions that are there, what percentage are for non-abortion related reasons? So, in other words, how many of the 300,000 are taking it because of abortion? Anyone happen to know? Yeah. Is it like a lot?
An increase in
40% is unrelated to abortion? Really? That high? Okay. Fair enough. All right, so 40%. So it's only what, about, as I have to do math in my head. So you're talking about 150, like 165,000, 170,000 women take it every year for the purposes of abortion? Give or take, something like that? Okay.
Emergency room visits, and indeed treated women suffering from abortion drug harms dozens of times. Women have suffered tens of thousands of times. That respondent doctors will be forced to manage abortion drug harm is not a bug in FDA's system, but part of its very design. Ruling against respondents on standing here would allow federal agencies to conscript non-regulated parties into violating their consciences and suffering other harm without judicial recourse. Article 3 neither demands nor permits this. FDA's outsourcing of abortion drug harm to respondent doctors forces them to choose between helping a woman with a life-threatening condition and violating their conscience. This Hobson's choice is intolerable. On the merits, FDA failed to comply with basic APA requirements. In 2021, it eliminated the initial in-person visit based on data it says elsewhere is unreliable. And in 2016, it failed to consider or explain the cumulative effects of its wholesale removal of safeguards. These actions fall far short of what the AP requires. This court should affirm. I welcome the court's questions.
Too strong on emotionality, not enough on objective reality. I find her argument too much of an emotional appeal.
Counsel, you assert an injury on the part of the alliance of diverted time and resources. Isn't that just the cost of litigating, of pursuing this litigation?
I don't think so, Your Honor, for a couple of reasons. First, what respondent doctors have done here is chosen their particular practice as well as structured that medical practice to bring life into the world. When they are called from their labor and delivery floor down to the operating room to treat a woman suffering from abortion drug harm, that is diametrically opposed to why they entered the medical profession. It comes along with emotional harm. Dr. Scott talks about these being heartbreaking situations and some of the most stressful work she's had to deal with, Your Honor.
Well, I understand that, but I'm talking about the injury of having to divert resources to litigate this.
Oh, with respect to the organizational standing?
The alliance.
Absolutely, Your Honor. So we think Havens Realty is on all fours with this case. The best evidence of that, I believe, is the FDA's reply brief. The government resorts to the underlying briefs in the case to say that there was a contract and an economic harm. But this court's case specifically said that the fact that the nature of the harm was, quote, non-economic did not prevent the court from finding an injury. In Havens, the court looked to two things, whether there was an impairment of the organization's mission, and second, whether there was an expenditure of resources. Both things are satisfied here. If you look at how our organizations have been harmed, they've been forced to divert resources from speaking and advocating for their pro-life mission generally to explaining the dangers of the harm from abortion drugs. One of the primary reasons that that's required is because in 2016, FDA took away the requirement that abortion providers report adverse events.
Well, but that would be anyone who is aggressive or vigilant about bringing lawsuits, just simply by using resources to advocate their position in court, you say now causes an injury. That seems easy to manufacture.
So I don't think that's true in this case, Justice Thomas. I acknowledge that the lower courts have cabined Havens to say where you have sort of prelude to litigation types of activities. In those sorts of cases, those resource justifications don't count. In this case, if you look at respondents' declarations, they note that they have performed studies, they've analyzed studies. Several of those are in the record, and they're not short. They comb through Medicaid data, they comb through FAERS data, so they get at the true nature of adverse events. And all those sorts of things are neither a prelude to litigation, nor would they have occurred but for FDA's unlawful conduct in this case.
Counsel, in the line you quoted about economic harm, that had to do with the fact that they didn't intend, through their testers, to rent an apartment. And so there was no economic loss to them or gain to them from renting the apartment. But what was, I think the SG is pointing to, is that they provided services on their own. It wasn't just the members' services that they were relying upon. They were providing services to people to help them rent apartments. And so that's a very important distinction from here, separate from the individual.
Hey, the sync seems to be back. Yay!
Defendants' claims of standing based on wasted resources, their resources. The organizations are not losing anything. So their job is to do exactly what you're talking about, and they're doing it. They're investigating certain problems, but that's not an injury that's redressable by this, by vacating this rule.
So a couple of things, Your Honor. This Court's opinion in Havens did not rely on the economic nature at all. Again, I'd point, Your Honor, to the line in Havens where the Court says the non-economic nature of respondents' interest in housing. They were speaking broadly. Again, you have to dig to the underlying briefs to find that economic interest that this Court did not rely on. With respect to our own injury, it's absolutely redressable. For example, if the regulations are put back in place, the protections whereby individual abortion providers need to provide information about adverse events, that would provide our respondent organizations with more accurate information about the harms from abortion drugs.
Counsel, can I ask you, about the remedy and sort of the way that I was talking with the SG. I mean, it makes perfect sense for the individual doctors to seek an exemption, but as I understand it, they already have that. And so what they're asking for here is that in order to prevent them from possibly ever having to do these kinds of procedures, everyone else should be prevented from getting access to this medication. So why isn't that plainly overbroad scope of the remedy the end of this case?
So with respect to the premise of that question, Justice Jackson, I don't think our doctors necessarily are able to object for two reasons. One of this is the emergency nature of these procedures. As the FDA acknowledges, many women do go to the emergency room, and if we just think about what that might look like, take Dr. Francis. She's on the labor and delivery floor supervising.
I'm sorry, I don't want to hypothesize. Tell me in her declaration where she talks about not being able to object or pose a conscientious objection.
She talks about, Your Honor, being
I mean, can you point me to any place in the declarations where a declarant states that they attempted to object but were unable to?
No, Your Honor, for two reasons. One, these are emergency situations. Respondent doctors don't necessarily know until they scrub into that operating room whether this may or may not be abortion drug harm. It could be a miscarriage, it could be an ectopic pregnancy, or it could be an elective abortion, Your Honor. In addition, the government simply cannot get its story straight on EMTALA. If you look at the district court brief in that case, we just heard that the Church Amendment applies, and while we would love for this court to adopt that position, they told the district court the very opposite.
All right, let me ask you this. If we were to find that there are conscientious objections that say hospitals take them into account and these doctors do have a way to not do these kinds of procedures, should we end this case on that basis?
No, Your Honor. We would welcome that holding, but it's not broad enough to remedy our doctors' harm.
Why?
Because these are emergency situations. They can't waste precious moments scrubbing in.
No. I'm saying assuming we have a world in which they can actually lodge the objections that you say that they have. My question is, isn't that enough to remedy their issue? Do we have to also entertain your argument that no one else in the world can have this drug, or no one else in America should have this drug in order to protect your clients?
So again, Your Honor, it's not possible given the emergency nature of these situations.
Counsel, let me interrupt there. I'm sorry. I think Justice Jackson's saying that let's spot you all that, okay, with respect.
Wow, it's not a good day. It's not a good day when Justice Gorsuch is like, yeah, you're not answering Justice Jackson's question. That's a bad day. That's a bad day. It's like the Justice Jackson has tried to ask this question twice now, and you're not answering the question. And so Justice Gorsuch is over here like, yeah, you're not answering the question. So I'm going to beat you to death for a while. Yeah, it's rough. That's a rough day, man. That's a rough day. All right, Justice Gorsuch is going to beat you to death for not answering Justice Jackson's question for a while.
To your clients. Normally in Article 3, traditional equitable remedies, we issue, and we say over and over again, provide a remedy sufficient to address the plaintiff's asserted injuries and go no further. We have before us a handful of individuals who have asserted a conscience objection. Normally, we would allow equitable relief to address them. Recently, I think what Justice Jackson's alluding to, we've had, one might call it a rash of universal injunctions or vacatures. And this case seems like a prime example of turning what could be a small lawsuit into a nationwide legislative assembly on an FDA rule or any other federal government action. Thoughts?
Yes, Your
I love it. He winds up defending Jackson and making a conservative point. Well, I consider it to be a conservative point, at least. He's like, he defends Justice Jackson and then turns it into a conservative idea of there's a problem with universal injunctions, universal vacators, universal things. We've had a rash. I don't know if I go that far, but it definitely has increased where we're having these like universal things. And maybe this is this idea of who should be able to issue these things on nationwide injunctions, universal injunctions, who should be allowed to. And so he's like, maybe the problem is the universal injunctions. So he defends Justice Jackson and makes a conservative point at the same time. Good deal.
Your Honor, again, I have to say that I think it's impracticable to raise a conscious objection, but even spotting that, I think the district court remedy here was perfectly appropriate under Section 705. Section 705 grants the reviewing courts the authority to issue all necessary and appropriate relief. And as the government acknowledged in oral argument in Corner Post, when the parties before the court are non-regulated parties, the only avenue in which they can possibly get relief, and of course that's sort of the think went on of equitable relief, is that the parties before the court get it. And that's for, as in this case, a state issue, or in other cases, a vacature. And that's because without that sort of relief, the very parties before the court won't get it.
I think
why can't the court specify that this relief runs to precisely the parties before the court, as opposed to looking to the agency in general and saying, agency, you can't do this anywhere?
So I think, Your Honor, that might be impracticable. If we're thinking again about the emergency room situation, would Dr. Francis again have to know when she's in the emergency room whether this is a miscarriage, an ectopic pregnancy, or an elective abortion? This is what she does day in and day out. And so it seems like to say that these would run to particular plaintiffs would be missing, that the FDA regulations would still be in place and permit things like mail-order abortions. They would have removed the reporting requirements. And if we look at the merits of what FDA did in 2021, FDA relied on two things. They relied first on the FAERS data.
Counsel, before you pivot back to the merits, and I can understand your impulse there, but I went back and looked, and there are exactly 0 universal injunctions that were issued during Franklin Delano Roosevelt's 12 years in office, pretty consequential ones. And over the last 4 years or so, the number is something like 60, and maybe more than that. And they're a relatively new thing. And you're asking us to extend and pursue this relatively new remedial course, which this court has never adopted itself. Lower courts have kind of run with this. And I just want to give you one more shot at that.
Sure.
So again, like from the conservative framework, the critique against universal injunctions, global injunctions, especially by the lower courts, which, you know, to be fair, it's like, yeah, how does that work exactly? Why can some district court grant global relief? That seems odd. I mean, the district court has jurisdiction over its district, and now suddenly it's issuing an injunction that applies nationwide. And so that seems a little odd. Or even the courts of appeal. I mean, the courts of appeal are still limited in their jurisdiction. Even the Ninth Circuit is only like most of the Western United States. So, like, why can the Ninth Circuit issue an injunction or affirm an injunction that applies to New York, by way of just random example? And so there's certainly been grumbling among the more conservative people about these universal injunctions and global injunctions. And so, like, you know, if this case, it will certainly be an interesting thing if the Supreme Court winds up affirming the FDA and also simultaneously takes a big swipe at the universal global injunctions. That would be a really interesting thing, because they make the larger point over like the thing. So maybe they can even get the left members of the court to sign off on that, which would be interesting. So maybe they say, you know, that the relief, maybe they say the relief is inappropriate, or they even say it's just for these people and take a huge swipe at the universal global injunctions. So now we're playing a different game. Let's decide this other issue that we can bury or we can sort of hide in this issue. So it's like, okay, maybe we'll take a swipe at the universal injunction thing. It's an interesting idea from the conservative end of the bench. So, okay, yeah, all right.
Your Honor, so again, the APA, of course, encapsulates equitable remedies, and as Pomeroy and others have said from the beginning of the 19th century, equity requires that the parties before the court get relief. In this instance, again, as the government pointed out in Corner Post, where you have non-regulated parties, those parties could be farmers, they could be ranchers, they could be the seed farms in Gertsen, but their only availability for relief is if the court does something to the FDA order or regulation at issue. Otherwise, those parties are simply out of luck, and that's inconsistent with equity.
May I ask Ms. Holy about your basic theory of standing? And just this is a clarification question as much as it's anything. When you did your 1, 2, 3 in your opening statement, it sounded very probabilistic to me. I mean, I don't remember exactly what the 1, 2, 3 are, but, you know, let's say it's something along the lines of we represent a lot of doctors, and there are a lot of women out there taking Mifepristone, and some fraction of them are going to have adverse events, and some fraction of those are going to come to the emergency room, and so there's some probability or likelihood that one of our doctors who has a conscience objection is going to come face to face with one of these women who has an adverse event. Is that your theory?
No, Your Honor. What we think really shows that respondents have standing here is FDA's own acknowledgments. I would point you to JA 384. And in regulating Mifepristone, FDA has continually said that emergency room doctors and OBGYN hospitalists are critical to the safe use of drugs.
Well, I think then it is your theory. I mean, you're just saying even FDA admits that there are going to be some adverse events. People are going to show up in emergency rooms. People are going to come face to face with one of our doctors who objects to some aspect of the treatment. That's the theory, yes?
Well, we certainly think all of that is true, but we don't think it's a problem with probabilistic standing, as was the case under Summers, for 3 reasons. First, Summers involved unidentified members. Here we have 7 named plaintiffs. In addition, no one in Summers, at least that was still part of the case.
So does your theory really depend on your having at least one person? Because I take Summers to be saying these probability theories, they sound very nice. They have nothing to do with our Article 3 requirements. You need a person. You need a person to be able to come in and meet the court's regular standing requirements. So you agree with that, yes?
I think that's correct, Your Honor, yes.
Okay, so who's your person? I know you have 7 of them, but if you had to pick one and say, go read that declaration, and that declaration is going to tell you why we're entitled to be up here. Who's the person?
So I have to pick 2, Your Honor, but Dr. Francis and Dr. Scott.
Okay, and what about those 2 doctors gives you the kind of imminent injury, let alone the traceability, that we've typically required?
So to speak to Dr. Francis at the beginning, there's been some confusion, I think, about the precise nature of the conscience harm. But if you look at JA 155, paragraph 15, she talks about her and other APLOG members who object not only to taking the life of an unborn child during an elective abortion, but also to, quote, completing that process. That echoes the CMDA declaration at 142 and 143. It's also consistent with...
Has she ever been, because I read that declaration pretty carefully, what actual emergency treatment has she participated in that she objects to and that she has stated an objection to?
So the prior page, Your Honor, JA 154, talks about a DNC, which she was required to perform due to a life-threatening emergency.
She herself performed that.
That is correct.
And did she have an opportunity to object? Did she object?
No, Your Honor. Again, these are life-threatening situations in which the choice for a doctor is either to scrub out and try to find someone else or to treat the woman who's hemorrhaging.
Well, usually conscience objections, the way people with conscience objections do this is they make those objections known. And, that may be harder, it may be easier in a particular context, but most hospitals have mechanisms in place, routines in place to ensure that doctors who are allowed to do this, in advance, right, and are allowed to do it at the moment, They say so. And when I looked at Dr. Francis's and Dr. Scott's, there's just nothing that you have there that suggests, this is like there are, other requirements that you need. But at the very least, to be able to say, well, this happened to them in the past, I don't think you have it for either one of those doctors.
So I think we do, Your Honor. Given the emergency nature, it's simply impracticable to have a objection lodged prior to understanding what's going on in that operating room. And again, I'd point, Your Honor, to the District Court Fifth Circuit brief in EMTALA, where the government says that neither the church nor any of the other sponsors of those federal conscience protections intended them to apply in emergency situations. So it's a lot to ask our respondent doctors to go up to the top floor and litigate this with the general counsel when the federal government's telling them they don't have a conscience protection.
But the federal government just told you do have a conscience protection. So I don't even understand what's going on at this point. I mean, it's simple and practical to have an objection lodged prior to understanding what's going on in the operating room. But even if you had understanding, it seems like you wouldn't have objected. That's the problem, because, these are life-threatening situations in which the doctors either scrub out and try to find someone else or treat the woman who's hemorrhaging. So that's a hypothetical where you do have knowledge, it seems to me, right? So it's like, well, these are my choices. I can scrub out and not do this, or I can do it. And it's like, but my conscience doesn't want me to. And it's like, it's like either, you have to kind of pick a side on this one. And I it's not a fun decision, to be sure. But if your conscience is, I can't do this, because it seems to me at that point, the answer seems to presuppose the doctor somehow knows, right? So it's like the doctor somehow knows. And it seems to me if the doctor somehow knows, it's like, well, at that point you have two options. Apparently, it's like you can scrub out, not do the procedure, and find someone else who can, if such a person exists, and maybe such a person doesn't exist, and maybe the patient bleeds out and dies, or you do the procedure. Now, let's presuppose that they're protected if they choose either option by the relevant law. And it's like, well, okay, now it's a decision of conscience. And it's like, well, what does your conscience tell you? It's like your conscience is being put to the test, And so, well, if your conscience tells you I should save the woman's life, then that's what your conscience tells you. So you no longer have a conscience objection, or like, because you've made the conscience choice about which one your result stems from. So like, it seems that she's shooting her own argument in the foot, if I'm understanding what's going on. Yeah, they want to have their conscience objection and not ever be put in a position where they'd have to raise it. Yeah, that's not how that works. That's not how that works. It's like, if you have a conscience objection, you have a conscience objection, and you just have to do the thing, as hard as it is. And that's the nature of the thing. It's like, if you have a conscience objection, you have a conscience objection. I don't know why this example comes to mind, but sure, let's go there. World War II, Private Desmond Doss. Private Desmond Doss is a conscientious objector who joins the military for the purpose of becoming a combat medic in the military. And according to the law, he can have his cake and eat it too. He is allowed to do this. He is allowed to have his cake and eat it too. He's protected by an act of Congress. And he cannot be compelled by order to waive his rights, because the Congress of the United States is the one that creates and forms the military, and they're the one that creates the rules for the military. So his military commanders cannot order him to bear arms. He's allowed to defy orders because it's not a lawful order, because Congress says it's not. And then he goes on to, go to, the battlefield and save like everyone's lives, and he wins the goddamn Medal of Honor. Never having bared a weapon never having shot the enemy, goes into combat with, his cross on his helmet and his medical bag and no weapon of any kind, and just saves everyone's lives, and he wins the goddamn Medal of Honor because he's such a hero. Okay? So that's what conscience looks like. That's what it looks like. It's like, yes, I want to save lives. Everyone else is going off to war. I don't think I should be exempted, but I also don't want to shoot anybody. Fortunately, the Congress of the United States says I can have my cake and eat it too. I can do this. I can, in fact, join the military, and I can say, you can't make me carry a gun. That is apparently an option that he chooses, and then actually does his job and wins the goddamn Medal of Honor. He's a goddamn hero. So, yeah, it's like, look, you got to pick an option. Look, it's like, I'm sorry that you don't want to be in this position. I'm sorry. Yeah, this is the equivalent of basically... This would be the rough equivalent, I guess, at this point, of Private Desmond Doss before he ever enlists says, you know what? No one should have to be in this position. No one should have to bear arms in the military, because it's really, really bad for anyone to bear arms, even in defense of the country. So I don't want to be put in a position where I'm going to be around people who have guns, or where my commanders try to force me to carry a gun. It's like, I don't want to be put in that position. So rather than, not join the military, or if he was drafted, either way, it doesn't really matter. I think he voluntarily joined, but it wouldn't matter either way. Rather than do that, I want to sue to make sure that no one can carry guns, so I'm never put into the choice of having to carry a gun that I don't want to, because that would be unfair. And it's like, no, that is not an option, man. It's like, dude, if you're a man of conscience, you're a man of conscience. Don't join the war and don't carry a gun. But, so there's like, oh, I never want to be put in this position. I was like, well, I'm really sorry you don't want to be put in that position, but I mean, you can't have everything all at once. You cannot be a doctor. That's always an option. You cannot be a doctor, and you can just say, I'm not going to do this, and the patient dies, and that's too bad, so sad. Too bad, so sad. I'm not going to provide care to you. Sorry, you're bleeding out there and everything, but that's not my problem, which apparently is an option. But if that's what you believe, that's what you believe. So, suck it up, get some big girl balls, suck it up, get some big girl balls, and make the decision. Make the decision. It's like, I don't want to make the decision.
Is it true that our standing decisions have not relied on...
Would it be fair to force the doctors to choose between doing abortions and letting the patients that they could save die? Yeah, apparently, yes. Yeah, that would be a valid option. Yes. Because, I mean, the Hippocratic Oath, after all, is first do no harm. Right? I mean, that's the classic Hippocratic Oath, first do no harm. So if your view, which, by the way, is a negative injunction, it's an injunction to not do things. Right? That's a negative injunction. Don't cause harm. That's not telling you to do anything. It's telling you to not do something. It's a negative injunction. So if in your view, saving the patient is doing harm, then, do you believe that or don't you?
On probabilistic determinations like the Department of Commerce case. The court said there was standing because if a question about citizenship was included on the questionnaire, a certain percentage, an unknown percentage of residents would then not fill out the census at all, and therefore it was probable that there was some risk that New York State would risk losing a representative in the House of Representatives, or would risk losing money under some federal program.
And of course, this problem, as pointed out in chat, can also be significantly reduced by not choosing fields of medicine in which you'd be faced with this choice. Because this choice would only come up, like the only scenario where this choice is coming up is because you're the ER doctor. You're the crisis ER doctor. So, like, you could be a surgeon and just not be not the ER surgeon. Like, this only comes up if you're the ER surgeon. It's a pretty narrow niche as far as we're going, by the way. It's like, you could just like not do that. You could be a different kind of surgeon, and you're just never on call for the emergency room because you just don't roll that way. There are surgical positions like that. You could also not work at a hospital. That also solves the problem. You could be a surgeon who doesn't work at a hospital, or whatever. Like you don't work there full time, or whatever. It's like you just have admitting privileges at the hospital, but you don't work at the hospital. You're independent and you do your surgery, and sometimes you do them at the hospital, but you have admitting privileges and you can work there, but you're not an employee of the hospital. So that solves your problem right up. Or any other field of medicine. It's like I want to have everything all at once. I want to be an emergency ER surgeon, and I don't want to ever be faced with this choice. Because my conscience is being put to the test. Because my conscience is faced with, don't do the thing because it facilitates abortion but kills the woman. Well, strictly speaking, it doesn't kill the woman. The woman dies because I'm not doing the thing. So strictly speaking, I'm not killing the woman. The woman just dies. So option number 1 is don't do the thing, the woman dies, or option 2, do the thing, and I've somehow facilitated abortion. And you don't really like that choice, do you, very much? Because it makes your conscience very unhappy. And so you want to solve that problem. You want to solve that problem by imposing on the world. I want to solve that problem not by choosing some other specialty, not by becoming some other surgeon, not by, whatever. I want to solve that problem by imposing on the world. Which, incidentally, by the way, according to the Solicitor General, this hypothetical has never occurred ever. There's never actually been a real conflict. Now, maybe it's because the people that are performing the surgeries have never raised the objection. But then again, how would the Solicitor General know about it? So maybe there's a bunch of people who are really silently in their own mind, I really don't want to do this. But then again, how would they know about it? So, it's hypotheticals built on hypotheticals. You're trying to create this ultra rare scenario, which is pretty rare to deal with, this hypothetical. This is a pretty unlikely hypothetical that apparently is never manifested in the real world. And even if it has, there's never been a conflict that's manifested in the real world, and blah, 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 blah. That's the answer. It's great.
Program, and you put together this chain of probabilities, and that was sufficient to establish standing.
We'll look up whether it's a shield for civil lawsuits later. I don't know. We'll look it up later.
Absolutely. We agree with that, Justice Alito. In particular, you can look at the Gertson Seed Farms case, which also involved non-regulated parties. And this court looked at the distance that bees might fly in order to pollinate seed farms. So it's certainly true that data is appropriate to consider in determining.
Somehow, Cowley the fish bee makes an appearance in the middle of this oral argument. Interesting.
Determining whether there's a substantial risk under SBA list. Here, the FDA admits, this is at 533, that between 2.9 and 4.6% of women will go to the emergency room. It acknowledges, this is at 542, that up to 7% of women will need surgical intervention. And when the FDA talks about there being no increase in adverse events from the increased gestational age, the only way they can say that is by ignoring surgical interventions. And that's because JA 207, the FDA...
Counsel, what do we do with the fact that these two people that you rely on, Francis and Scope, that Indiana and Texas have abolished abortions and abolished them by pills or otherwise. Now, we can get into whether other people are illegally breaking the law and supplying it contrary to law, but what does that do to your probability, which is it's already infinitesimally small?
Yeah, it's a pretty good point. The state of Texas, in its infinite wisdom, has decided to outlaw abortion, including using the pill. So we've gone from a pretty unlikely scenario to a basically impossible scenario. So your conscience problems are now even further mollified by you can live in a state which doesn't allow abortions. So you could go practice medicine in one of those many states. So now my objection is I want to practice law specifically in California, ... And it's like, yeah.
Because there are thousands of hospitals in the country, 50 states, I don't know how many territories, thousands and thousands of places where pregnant women go who may be suffering from miscarriages or otherwise, to know or to even imagine how one doctor is going to ever actually see a patient that he or she is going to be forced to intervene on their behalf, but then add to it that this is illegal in these states.
So I think the best answer, Justice Sotomayor, is that past is prologue. In our declarations, we have 3 doctors who have treated harms from abortion drugs at least a dozen times. We have 2 examples when women went out of state. And if you go out of state, there's a higher likelihood you're not going to have a follow-up visit. What the FDA's regime has done is turn ER rooms into those follow-up visits. We've had that happen with both Dr. Jester, where a woman went to New Mexico and returned to Texas, as well as Dr. Johnson, where a woman went to Illinois and returned to Indiana. Indeed, according to Guttmacher, 1 in 5 abortions take place out of state in surge states like New Mexico, like Illinois, the border states in which our doctors reside.
Ms. Hawley, can I take...
Okay, and just like I'm not sure how it's necessarily folds into the legal analysis generally, but I also object on the idea that you are now trying to impose on other states. It's like, yes, the women went to the other state and now they're back in this state. And like, basically you're trying to impose on other states because they allow abortions and your state doesn't. You're trying to, okay. My sympathy levels for these doctors is diminishing rapidly in terms of their problems. And standing is, of course, an issue. And if they don't have standing, I don't really care about very much, because they don't have standing. And my willingness to care about these doctors and their problems is diminishing with every word she says. It's like I am now at the point where I no longer care about, well, I no longer care is not the right phraseology. It is now of lesser importance in my mind. How about that? It is now of lesser importance in my mind whether the FDA complied with the law, whether or not the mailing thing is legal, whether or not blah, blah, blah. It's now of lesser importance in my mind than these doctors are apparently a bunch of crybabies in ways that are becoming more and more unsympathetic with every passing moment. I don't want to ever have to deal with the situation.
Take you back to the affidavits and some of Justice Kagan's questions. You were talking about Dr. Francis, and as I read her allegations, or as her affidavit reads, she said that her partner was forced to perform a D&C when there was a living fetus, and she said she performed a D&C on a woman who was suffering serious complications. But the fact that she performed a D&C does not necessarily mean that there was a living embryo or fetus, because you can have a D&C after, a miscarriage.
That is correct.
So if that's right, I mean, I think that the difficulty here is that, at least to me, these affidavits do read more like the conscience objection is strictly to actually participating in the abortion to end the life of the embryo or fetus. And I don't read either Scott or Francis to say that they ever participated in that. So do you want to address that?
Sure. So first, Justice Barrett, I think Dr. Francis's combined with CMDA can be read for the broader conscience harm. Again, that's how the district court understood that. I'd point you to pages 7 and 8. That's how both the state panel and the Fifth Circuit understood respondents' conscience harms to extend beyond simply requiring the ending of an unborn life. And with respect to even the more narrow conscience harm, to whether a doctor may need to end a life, we think there's still a substantial risk of that occurring. If you look at the numbers of the increase from 7 to 10 weeks in gestational age, that means that 3.1% of pregnancies will be ongoing, requiring a D&C. We know at ROA 870 that 55% of those D&Cs occur in the emergency room. This is a substantial number of women suffering abortion drug harm. Again, Guttmacher says 650,000 women took the drug in 2020.
But not all those D&Cs will involve a pregnancy that would otherwise be viable or an embryo or fetus that would otherwise be living, because you can have complications or excessive bleeding even after the abortion is complete in that respect, but there's pregnancy tissue remaining.
So with the 3.1, Your Honor, is ongoing pregnancy.
Is ongoing
yes.
pregnancy.
And FDA says at JA 542 that up to 7% will need surgeries to stop either bleeding or ongoing pregnancies or failures.
How many members of your organization? You have a broad number of, doctors that are in your organization. I gather dentists, some doctors who are retired. How many
I know it's not exactly correct because the organization just happens to include dentists. But if you're a dentist and somehow you're involved in any context with regards to an abortion, I'd really love to know how. How did that happen?
Members of your organization are OBGYNs who practice in hospitals who might be called into these ERs?
There are hundreds of them, Your Honor, but I think, may I finish? Sure. I think in particular that the named plaintiffs are OBGYN hospitalists who spend most of their time on the labor and delivery floors, but also are called to the OR to treat these sorts of emergencies.
Ms. Hawley, can you clarify the broader conscience harm from the narrow one? Because I had understood the conscience harm as Justice Barrett does, but you suggest that there's a broader one. So what is that?
Yes, Your Honor. I'd point you to pages 7 and 8 of the district court opinion. And the district court understands the conscience harm to be either taking the life of an unborn child, which would sometimes be required. Dr. Francis testifies to a partner who was required to do that because of emergency situations.
That's what I understood the narrow one to be, right? I'm participating in a procedure that is ending the life.
Yes. I think
that's narrow. Okay, yes. So what's the broader one?
So the broader one, Your Honor, is being complicit in the process that unnecessarily takes an unborn life, such as performing DNC.
Is it that if the dentist reaches far enough down your throat? Lol.
Abortion, and it's really not that hard to see.
No, wait, I'm sorry. Complicit, like I work in the emergency room and this is going on. I'm handing them a water bottle. I'm like, what do you mean complicit in the process?
So this court, of course, takes religious beliefs and conscience beliefs as it finds them. But what harms our doctors, Your Honor, is being involved in completing, in the terms of our declaration, an elective abortion. And it's really not that hard to see why that might be a conscience harm if you think about what's involved in a
But
DNC.
you just said again, it's being involved in completing an elective abortion. So I took that to be the conscience objection. I think what Justice Jackson is asking, or what I asked before, or what Justice Barrett is there any broader conscience objection that appears, I'm not sure I care all that much about the district court, but that appears in the declarations?
Yes, Your Honor, and in this sense, completing an elective abortion means removing an embryo fetus, whether or not they're alive, as well as placental tissue. Again, Dr. Francis talks about being required to perform a DNC, this is at 154, and remove placental tissue.
Whether or not there's any live tissue.
Yes, Your Honor. And again, this makes sense.
And where are we looking for that?
So I would point, Your Honor, to JA 155, paragraph 15, where again she talks about completing an abortion. The CMDA declaration at pages 142 and 143 also describe this sort of complicity harm from being involved in an elective abortion, Your Honor. And again, these doctors performing a DNC must scrape out a woman's uterus of a child, of the embryo, the fetus, or placental tissue. And this court has recognized harms like that in cases like Little Sisters of the Poor, as well as Hobby Lobby.
I'm not so sure about that citation to Hobby Lobby in this context. It feels like a reach. A lot of this argument feels like a reach.
No, go ahead.
It's my understanding that sometimes the completion, it doesn't involve surgical intervention. Do you have a sense of how often? I mean, we may get all the way down the chain to the doctor is there, the person is having an emergency procedure. My understanding is with some of these chemical abortion scenarios, the completion occurs by prescribing additional medication. Do you have a sense of how many times the completion is that route and could be done by another physician as opposed to your clients in doing a medical procedure?
So that second dose, Your Honor, of misoprostol has been part of the regimen since 2016, really I think all the way back to 2001, but it's been approved by FDA since 2016. So the best numbers we have from FDA are still consistent with that, and that means that 3.1% of pregnancies at 10 weeks will be ongoing. I'd encourage you to look at JA 405 through 407, and this explains that these risks go up without an in-person visit.
Yeah, no, I guess I'm just trying to get at, I'm still working on how many circumstances or how often it would be that your clients actually have to complete the procedure in the way that you are describing.
So Dr. Scott talks about doing this at least a dozen of times, either a DNC or a suction aspiration abortion to remove, again, embryos, fetuses, or placental tissue. In addition, Your Honor, if you think about the numbers, again, it says 3.1% at 10 weeks, and this has only gone up. In 2020, FDA told this court that the in-person visit was both, quote, necessary and minimally burdensome, and necessary to preserve women's health, precisely so these sorts of situations occur less frequently.
Thank you, counsel. Justice Thomas.
Ms. Hawley, I'm sure you heard the answers of the Solicitor General and the counsel for Danko with respect to the Comstock Act. I'd like you to comment on their answers.
Sure, Justice Thomas. We don't think that there's any case of this court that empowers FDA to ignore other federal law. With respect to the Comstock Act is relevant here. The Comstock Act says that drugs should not be mailed either through the mail or through common carriers. So we think that the plain text of that, Your Honor, is pretty clear.
When did you first raise the Comstock Act?
So I believe the Comstock Act was first raised at the district court, Your Honor, but we think that exhaustion does not apply for two reasons. First, it would be plainly futile as FDA's adoption of the OLC memorandum goes. In addition, this is a whole other kettle of fish, but if you look at Section 704, exhaustion is only required in two instances, either when required by a statute or when by an agency rule when that agency rule is stayed pending litigation. This is consistent with this court's case in Darby. The lower courts have taken conflicting opinions, but we think the better reading of Section 704 is that there's no exhaustion required unless either a statute or agency rule stays the proceeding during judicial review.
Justice Alito, Justice Sotomayor, Justice Kagan.
May I ask about
abortion drugs can't be mailed. Abortion drugs specifically can't be mailed. It's the Comstock Act from the early 20th century. That's what they're talking about.
your view of traceability? And, you know, on one understanding, and I want you to tell me if you agree with this, that even beyond proving whatever injury you're trying to prove, that you have to show that that injury is traceable to the 2016 and 2021 FDA actions that you're challenging. And, of course, that means showing that these incidents that you're talking about in the emergency room are caused by whatever incremental increase in risk there is as a result of those 2016 and 2021 actions. And I guess my first question is, do you agree with that statement of what you need to show? And if you do, how do you satisfy that? Why do you satisfy that?
So we believe, Justice Kagan, under the case law that we need to show that each the 2016 action and the 2021 action increase the risk of harm. And we think the way...
But then I guess what I'm saying is that you have to link whatever injury your members have to that increased risk. Do you agree with that?
We do, and we think we can do that for a couple of reasons. First of all, traceability, of course, is de facto. We're not in the Paul's graph sort of world of tort causation. And when you look at the 2021 action, we think traceability is satisfied by FDA's own words. It says at JA 405 that without the in-person visit, this is the ANGER study, without that in-person visits, ER and other medical care is likely to increase, as well as surgical interventions. And these are the very same surgical interventions that harm respondent clients.
So there might be some dispute between the two of you as to exactly how big the increased risk is. But let's even take your view that there is, some measurable increased risk. How do you connect that risk to particular actions that your members have, to particular injuries that your members have undergone or imminently will undergo? I mean, it could be, the original risk.
So I think the declarations are actually quite clear on this. If you look at Dr. Francis's declaration, she says that when the in-person visit was enjoined in 2020 by a federal district court, that she saw an increase in emergency room visits from abortion drug harm. Dr. Johnson, Dr. Scott say the same thing. And again, this is entirely consistent with FDA's own numbers. Again, in 2020, FDA told this court that the in-person visit was necessary to preserve women's health because an in-person visit is the best opportunity to examine for things like ectopic pregnancy and accurately assess gestational age.
Thank you.
Yeah, it's a little bit hard to figure out how you can do this without going all the way back to 2000, and the Supreme Court, in the way they took the question presented, already doesn't want to go back that far. I mean, you tried it in the lower courts, but the Supreme Court doesn't want to do that. They don't want to go all the way back to 2000. Maybe just make sure that of the actual question that was actually presented. I'll just go back to Scott's blog to check out for sure. But I think the Supreme Court already said no on going back to 2000. So let me just take a quick look here. Make sure that I read the question presented correctly. Just a moment, please. Talk amongst yourselves. Okay, so there is an issue about whether the issue is timely. Oh wait, no, this is 2023 term. The petition for cert was denied in that case. Also a different one. So that they tried to bring this lawsuit already to the Supreme Court once, where they've Article 3. The question they presented is where they have standing to challenge the 2016-2021 actions. So the Supreme Court has already said in the petition for writ of cert, even in the petition for writ of cert, they only asked about 2016 and 2021, presumably because they got their teeth kicked in when they previously asked about 2020. So if you can't go back to 2020, which is when they approved the drug in the first place, if you can't go all the way back to 2020 and challenge the approval of the drug in the first place, now you're only talking about the delta of the increase. So that's fairly hard to make out a standing argument, because even if you got what you wanted, you still wouldn't win. You still wouldn't get what you want. Because what you want, apparently, doctors, I guess, what you want is to never be in this situation ever. That's the whole nature of the conscience objection, right? Because that would be what someone's conscience is, right? I don't want to ever be in that situation. One time is too many. That's the nature of what a conscience is, right? It's like one time is too many, typically. And so even if somehow you got the Supreme Court to reverse the 2016 and 2021 FDA extensions, you still wouldn't win, because it would mean that women would have to go back to the doctor's offices and the hospitals to get the prescription. But even in that hypothetical, it's not like there were never side effects. I mean, some people still went to the hospital. Now, your argument is more people are going to the hospital than they used to. But that's an argument of risk balancing at that point, right? Because it's an issue of like, well, how much are you willing to accept? which is a risk balancing analysis the FDA does with its time, right? Because there's probably no drug on this earth that doesn't have side effects and probably hasn't caused someone to go to the hospital at least once. You know, there's probably no drug on the face of this earth that hasn't caused someone to go to the hospital at least one time. So, like, okay, so it just becomes an issue of, like, how much are you willing to accept? What is the right threshold? Like, how much benefit for how much harm? And so, like, yes, it might be true that more people are going to the hospital, but whether or not that's a risk, whether or not that is a trade-off worth accepting is kind of what the FDA does with its time. And unless you can prove that the decision was arbitrary, you can't bitch about it anyway. And it's pretty hard to argue it's arbitrary, because it's just like, well, you know, we gain these benefits at the expense of these costs. But, you know, on balance, we think it's worth it. And it's like, okay, I mean, yeah, so your argument for standing just continues to go down and down and down with every passing moment, because now we're attacking fundamental redressability, right? To have standing, you need three things. There has to have been a bad, it has to have happened to you, and there has to be something that the court can do about it. That's standing, right? So we are now attacking, if we weren't already, we're attacking now the third element of standing. First of all, that there was a bad that first of all, there's a bad is questionable. That it happened to you has already been completely destroyed. And now we have a redressability problem, because even if the Supreme Court grants you everything you want, it doesn't redress your claim harm. Sure, you'll have to do it less frequently. You'll have to do this, you know, DNC thing you don't want to do less frequently. But what good is that to you? Because you still have to do it. So, like, you're still faced with the moral choice. You're still faced with the choice that you were faced with before. I guess you're faced with it less often, but, like, you're still faced with the moral choice. So you can't even get to there's no redressability. So this, yeah, the whole argument is just, it's not going great over here it's not going over here great for the people who are like, we'd really like to restrict the access to this medication, or I suppose more of the point, we'd really like to undo the FDA's thing in 2016 and 2021. Yeah, I don't think it's going great for you guys right now. It isn't the medication in question doesn't cause the ER bleeding. I'm not going to adjudicate the facts, obviously. Neither is the Supreme Court. I'm just going to assume it's true, and it doesn't matter anyway, by the way. It just doesn't matter, because I don't care. But, I mean, yeah, does it do it? I don't know. The drug probably causes some people to go to the hospital under some circumstances. It's probably true. So, whatever. It doesn't matter.
Justice Gorsuch? Justice Kavanaugh? Justice Barrett?
So General Prelager said that initial in-person visit had no requirement of an ultrasound or, any effort to detect fetal heartbeat. So it wouldn't necessarily give an accurate read on gestational age or detect an ectopic pregnancy. So why would that why would the elimination of the visit necessarily increase the risks?
So I think, Your Honor, FDA's own data shows that those risks did go up. If you look at the Caresti study, it shows a nearly threefold increase in emergency room visits when you have the in-person visit and when you removed it. There was 5.8% with an in-person visit, and it was also in about 2.1 without.
Is that because doctors were just kind of voluntarily saying, hey, it would be a good idea to give you an ultrasound or try to detect a fetal heartbeat, or what?
So when FDA removed the in-person visit, Your Honor, it took away the opportunity to do that. I think ACOG, I think medical organizations agree that is best practice. So if a woman comes into a doctor's office, she's likely to get an ultrasound to accurately assess both ectopic pregnancies, diagnose or assess gestational age. But what's allowed under FDA's rules currently is to be able to order these online with a couple of screening questions, and I don't think that's nearly as good as an in-person exam.
Let me just pivot to the organizational standing question. So let's say that I'm just going to carve out and put aside the costs of filing a petition or litigation as harms to your organization itself. Explain to me what additional costs you might have incurred or how your resources were diverted in a way that would satisfy Havens.
Absolutely, Your Honor. So putting to one side the citizen petition, the APLOG declaration is clear that respondent organizations conducted studies and analyzed studies. This included going through the Medicaid data. It included going through the FAERS data to the extent it was available.
Is that it?
Okay. When Amy Coney Barrett asks you, hey, as an organization, what is the harm to you for this abortion pill? And then you give an answer and she says, that's it. Dude, just give up. Just give up. If Amy Coney Barrett can't find a harm in what you just said, as it relates to abortion, just give up. Yeah.
Well, those studies, Your Honor, I would point to one of them is at ROA 870, and before and after. And those are pretty comprehensive studies, Your Honor.
And are they to the end of the litigation and the citizen petition, or what are they to the end of?
To accurately assess the harm from abortion drugs, Your Honor. So I think it's absolutely separate from the litigation. And one thing to note with the citizen petition.
That's such a bad answer, at least in my humble opinion. What is the expense to you other than the litigation itself? Well, the expense is in accurately assessing the harm of the drug. Yeah, but why are you doing that? Why are you doing that? Would it potentially be with litigation in mind?
Is that is the only way in which anyone can raise a concern to the FDA. These proceedings go on between Danko and the FDA behind closed doors. This is not a notice and comment process. The first time anyone can raise these objections is a citizen petition.
Justice Jackson?
So what deference, if any, do courts owe the opinion of the expert agency concerning the safety and efficacy of drugs?
So under this court's administrative procedure precedents, Your Honor, APA review, of course, is not toothless. Instead, in this case, we're not asking that the court second-guess the agency determinations at all, but rather look at what FDA said. Again, in 2021, when FDA took away the in-person visit, it did so based on FAERS data. It says elsewhere cannot be used to calculate the incidence of an adverse event, as well as studies that says that JA 407 are, quote, not adequate.
I guess I don't understand how that scope of review is not second-guessing the agency. I mean, they're looking at studies, and you're saying that the court can look at studies, maybe different studies, maybe the same studies, and critique their conclusions about them. So what deference do we owe them at all with respect to their assessment that these studies establish what it is that they say they do about safety and efficacy?
I don't think that's an accurate portrayal of the APA claim at issue here, Your Honor. And the reason being, again, is we're just asking this court to look at what FDA said. The FDCA says you have to have adequate tests and test results, as well as sufficient information.
I understand, but didn't the lower courts go beyond that? I mean, representations were made here today that the lower courts actually relied on studies that have since been found discredited and removed. So they were obviously looking at not just what the FDA was looking at in order to make their assessment. So are you asking us to just look at the FDA and not anything else?
So yes, that claim is not even before this court. But with respect to the two claims that are before the court, the 2016 and the 2021, we think the FDA's own statements here are arbitrary. In 2016, what the FDA said was we're going to look at individual studies, and then even though we say they're interrelated at J298, we're going to take all of the protections away at once. That was arbitrary in State Farm. It would be arbitrary here as well.
Thank you.
Thank you, counsel.
No, I don't think that conclusion follows at all. I don't think that conclusion follows at all. It's arbitrary in State Farm, therefore I don't think that conclusion flows at all. Yeah, I don't see the connection between those two things. Yeah.
Rebuttal, General Prelogar.
All right, General Preligar, finish them. Thank you for the 10 Canadian dollars with all the hearts. I do appreciate, Jasmine. It's very nice of you. Thank you.
Thank you. On associational standing, Mr. Chief Justice, you asked, where do you cross the line to get to a certainly impending injury? One thing the court has looked at is whether that harm has materialized in the past and how often. Now, it doesn't always guarantee there will be a future injury, but it can be a source of information. And here, what is so telling is that respondents don't have a specific example of any doctor ever having to violate this care in violation of their conscience. Instead, respondents have pointed to generalized assertions in the declarations that never come out and specifically say by one of their identified members, here's the care I provided, here's how it violated my conscience, and here's why conscience protections were unavailable to me. The fact that they don't have a doctor who's willing to submit that kind of sworn declaration in court, I think demonstrates that the past harm hasn't happened, and the reason for that is because it is so speculative and turns on so many links in the chain that would have to occur, and at the end would be backstopped by having the federal conscience protections in play. On organizational standing, my friend has pointed to the fact that they invested time in preparing their citizen petition. She says they voluntarily conducted studies and then generally refers to diversion of resources. If that is enough, then every organization in this country has standing to challenge any federal policy they dislike. Havens Realty cannot possibly mean that. The court should say so and clarify it is at the outer bounds and respondents don't qualify under that standard. On remedy, Justice Gorsuch, Justice Jackson, you pointed out the striking anomaly here of the nationwide nature of this remedy. Justice Jackson, you suggested maybe a more tailored remedy to the parties protecting their conscience protections should have been entered. The problem here is they sued the FDA. FDA has nothing to do with enforcement of the conscience protections. That's all happening far downstream at the hospital level, and the only way to provide a remedy based on this theory of injury, therefore, was to grant this kind of nationwide relief that is so far removed from FDA's regulatory authority that it's ultimately requiring all women everywhere to change the conditions of use of this drug. And I think it's worth stepping back finally and thinking about the profound mismatch between that theory of injury and the remedy that respondents obtained. They have said that they fear that there might be some emergency room doctor somewhere, someday, who might be presented with some woman who is suffering an incredibly rare complication, and that the doctor might have to provide treatment notwithstanding the conscience protections. We don't think that harm is materialized, but what the court did to guard against that very remote risk is enter sweeping nationwide relief that restricts access to Mifepristone for every single woman in this country, and that causes profound harm. It harms the agency, which had the federal courts come in and displace the agency's scientific judgments. It harms the pharmaceutical industry, which is sounding alarm bells in this case and saying that this would destabilize the system for approving and regulating drugs. And it harms women who need access to medication abortion under the conditions that FDA determined were safe and effective. The court should reverse and remand with instructions to dismiss to conclusively end this litigation.
Yeah, that's what good advocacy looks like. I don't know how she does it. I don't know how she does it. She's just too fucking good. I don't know how she does it. She is just too fucking good. Oh, man. All right, let's see if we can find these. Let's see if we can find these conscience provisions they refer to, because it'd be an area of federal law I've never seen before. So I have to figure out where they are. So this is going to take a second. Probably in the briefing somewhere. Probably in the, let's see, where would it be? Brief of petitioner, brief of petitioner. That'd be, Vided? Oh, okay. Let's see. Let's see if we can find where these provisions are, because I'm curious on what it says. Yeah. Good facts equal good case. Yeah, but just really good. Even with, I can't do that. She has an ability to put together in a package that I can't do it. It is not just that the facts and the law favor her. She has an ability to put together a frame that is as good as anyone I've ever seen. And maintain the frame, which is the challenging part. I mean, mere mortals can establish the frame, but keep maintaining the frame in this kind of environment? Yeah. All right, how do you spell conscience? All right, there it is. Did I actually spell it right? No, I didn't even come close. Give me a second. I have to find where this is in the statute so we can see exactly what it says. Okay. So looks like 42 USC 238N. If I am understanding, maybe this is the right one. Okay. Okay, so here's the federal law, what it has. 42 USC 238N, abortion-related discrimination in governmental activities regarding training and licensing of physicians. The federal government and any state or local government that receives federal financial assistance may not subject any healthcare entity to discrimination on the basis that the entity, so they talk about the protections for the entity. Oh, healthcare entity, is that like individual physician, a postgraduate physical training program, and a participant in the program. So basically doctors. May not subject doctors to discrimination on the basis that the doctor refuses to undergo training in performance of induced abortions or require or provide such training to perform abortions or provide referrals. The entity refuses to make arrangements for any of the activities specified, or the entity or attends a postgraduate physician training program or any other training in health professions does not perform induced abortions. So you can refuse to undergo training, you can refuse to make arrangements. Okay. And that applies to internship or residency programs. So that's nice. Let's see if there's anything else. Yeah. The Emergency Act, the Emergency Medical Act governs hospitals. Yeah. So that doesn't work. I'm trying to see if there's any other federal law that applies. Yeah, my memberships are on sale right now. They're on a discount from their normal $5.99 to 99 cents a month. So now's a good time to become a member. It is a discount. Yeah. Let's see. Federal. consciousness protection. I'm not doing a Google search. Let's see if there's something else. The church amendments. All right. They're on sale. Okay, 42 USC 300A-7. What a weird... You gotta love some of these citations sometimes, man. All right. 42 USC section 300A-7. Subsection A is omitted. Okay. The receipt of any grant, contract, loan under the Public Health Service Act, blah, 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 by any individual does not authorize a court or any public official or authority to require such an individual to perform or assist in the performance of any sterilization procedure or abortion if his performance or assistance in the performance of such procedure would be contrary to his religious beliefs or moral convictions. So, yeah, no court or public official or public authority can require any entity to make its facilities available for such a purpose, or require any entity to provide any personnel for the performance of such a service. Okay, no entity. How are they defining entity here? I'm going to assume it means doctors. Or I'll just assume whatever context I need to make it work, I guess. No entity, I guess this is hospitals now. No entity or medical facilities of some kind. Employers of doctors. No entity which receives a contract or loan guarantee under these relevant laws may discriminate in employment, promotion, or termination of employment of any physician or healthcare personnel, or discriminate in the extension of staff or other privileges to any physician or other healthcare personnel because he's performed or assisted in the performance of lawful sterilization or abortion, because he refused to perform or assist in the performance of such procedure or abortion on the grounds that his performance or assistance in performance of the abortion would be contrary to religious beliefs or moral conviction, or because his religious beliefs or moral convictions respecting sterilization procedures or abortions. So you can't do it because they did it, you can't do it because they didn't do it, and you can't do it just because they believe in it just generally. So you can't discriminate in employment for them doing it, not doing it, or just having thoughts on the issue. So you can't fire them for that reason. So the government can't fire, the government can't come after you, the licensing board can't come after you, and the hospital can't fire you for those reasons. And the same thing for a biomedical or behavioral research program. No individual shall be required to perform or assist in the performance of a part of a public health service program or research activity funded in whole or part under a program administered by the Secretary of Health if performance of such program or activity would be contrary to religious beliefs. So if you get federal money, long story short, you can't make either the hospital or the doctor do the abortions or sterilizations. And the hospital can't fire you for not doing it or doing it, as long as it's lawful. As long as the sterilization is lawful, they can't fire you for doing it, and they can't fire you for not doing it, and they can't fire you for having thoughts about it. So that's nice, I guess. And the medical boards can't, they can't force you to get training on it. So they can't force you to get training on the subject. They can't force you to learn about it, but you can if you want to. It's up to you. And they can't discriminate against you either way. So that's nice. So basically, it's completely up to you. It's up to you. Which I suppose is fair enough. You know? What law is that? Well, it's called the Church Amendments. It's specifically, in this particular case, it's 42 USC section 300A-7, subsection C. So that's, yeah. But the estate of the patient could still come after you. No, I don't think they can. Because what would be the basis in coming after you? Right? Because there would be no cause of action for coming after you. Because the only way to come after you would be for doing things or not doing things, right? And the only way to come after you for not doing things is if you have a duty, right? So, okay, so I want to sue you, the doctor. I want to sue you, the doctor. Okay, there's basically two ways for me to get there. You did something to me you weren't supposed to, or you didn't do something to me that you had to, right? That's basically the ways that you can sue anybody. So your standard medical malpractice case is because you did a thing that you weren't supposed to. You were supposed to practice medicine competently. You didn't. I got injured. So you did a thing you weren't supposed to, right? So if the doctor in doing the thing creates a problem, then you can sue them for that. Now, if they don't do the thing, then you can only sue them if they have a duty. But we just read just now how no government, no state government, no local government, no hospital, blah, 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 can make you do the thing. So it can't be part of your employment. It's an unlawful condition of employment. So if you have no duty to do it, I mean, if you say I'm willing to do it, then I guess, right? If you have no problem with it, then, and if you don't do it, then I guess, but then why weren't you? Because you were willing to do it in the first place. Right? So if you're like, yes, I don't mind, and then you don't do it for no particular reason, then sure. But if you're like, you know, I have a conscious objection and I'm not going to do it, it's like, well, what possible basis can I sue you for wrongful death? How do I make a wrongful death claim work? Or a medical malpractice claim work? I can't. I can't sue you for medical malpractice, and I can't sue you for wrongful death because you didn't do anything. And I can't sue you for medical malpractice or wrongful death because you were allowed to not do anything. So I have no cause of action. So I can't sue you. So, yeah, it doesn't work. It doesn't work. So I'm protected from lawsuit because you can't get to me. Yeah. Could I have a duty if you started an operation? Yes, that's fair enough. That is basically, that's assumption of the duty, and that applies standardly. That applies in standard law as well. So classic example, right? I see a person, I'm walking down the street, I'm walking down the street and I see a person drowning in a pond, and somehow, because it's magical hypo land, I know for an absolute certainty that I can save you with absolutely no risk to myself. If I don't do anything, I'm not responsible at all. Now, if I start to try to do a rescue, I might have a duty to follow it through. So if I start to effect the rescue and then abandon the rescue, yeah, now I have a problem. But if I never started at all, no. So yes, if they start the thing and then stop, then yes. But if they never started at all, then no. But that's pretty standard in, you know, law just generally. Didn't feds get seatbelt laws through the funding of withholding of highway funds? That was the drinking age. Seatbelt laws, I apologize. That was the highway funds was the drinking age. The reason why the drinking age is 21 in every state is because the feds bribed, slashed, you know, coerced them into doing it by withholding, I forget what it was, 10% or 15% of the highway fund, whatever it was. South Dakota versus Dole. I'm sure they did something similar with seatbelt laws. The doctor who walked out of the operation mid-operation because they noticed. How would you that they noticed the pills were the cause of the injury? I'd love to know how you were able to determine that in the middle of the surgery, that the pills were the thing that caused the problem. In the middle of surgery, I'd love to know somehow how you're able to divine by, you know, because you've opened the patient up and somehow, or whatever, somehow been able to determine that this was caused by a drug as opposed to a natural course of, how are you able to determine that with any reliability? I'd love to know. If you somehow magically came into the information, if you somehow magically got the information somehow in the middle of the operation, then you probably can walk away, to be quite honest, because now you just magically have the information for the first time ever. because you're allowed to refuse on the basis of your conscience. So if somehow you magically gain the information in the middle of the operation, you probably can walk away under the relevant law that we just read. But that's because it's what the law that we just read said. So yeah, I think you're okay if somehow you can make that determination. I don't know how you're doing this, but good luck. If the doctor creates the dangerous condition, well, if they create the dangerous condition in the first place, then sure, that's just med mal, but then they did something. Yeah, if the doctor creates the condition, then they did something. They created the condition. So that just is true just generally of tort law, basically, period. Right? If I create a dangerous condition, whatever that is, and then you befall as a result of the dangerous condition, well, that's kind of on me as a standard. That's just standard tort law. So sure, if the doctor created the peril, then first of all, if they created the peril, they have the duty to solve the peril. So there's that, right? You can't like walk away from your own peril. So if somehow they magically created the peril, then they do have a duty to perform the operation because they created the peril in the first place. And like, yeah, you have a duty to basically undo your own evil. It's like, yeah, you did the thing and you have a duty to undo the thing. And so, yeah, but that's just generally true. That's not having anything to do with being a doctor or not. That's just you create the problem, you have to solve the problem. That's easy enough. So a surgeon could generate a conscious objection mid-operation? No, that wasn't what we suggested. That wasn't the hypothetical. That's not what I said. I said that the doctor somehow magically knows in the middle of the operation that this was caused by abortion pills, as opposed to it being natural. That was the hypothetical. The magical fairy was the imparter of knowledge, not the imparter of conscience. I don't know what scenario this is where you're magically getting a conscience right in. I don't know what scenario this is. I suppose strictly by the letter of the law, then yes, somehow. If somehow the magical fairy just gave you a conscience right in the middle of the thing, and this is the first time you've ever had a conscience about it, and suddenly somehow you have a deep and abiding conviction because you're on the road of Damascus, and Jesus himself has somehow appeared and forced you to his feet, then sure. Yes, I suppose so. So the magical fairy somehow imposing this magical knowledge and or magical conscience, yes, I suppose you can walk away because, well, now you have the thing that you didn't have before by, magic. So yes, I suppose that would happen, sure. The drinking age was Louisiana 18. They were the last held up. But the drinking age hasn't been 18 in Louisiana since like the 70s. They were the last held up. They held up for a long time. But the drinking age in Louisiana is 21 too. It's 21 nationwide. Of course, any state could change the drinking age at any time. They just have to give up the highway funds. But every state likes money, so they don't do it. But they could. There's still a duty to refer, not under this statute, I think. No, there actually isn't. Not under this statute, there isn't. There is for the hospital, but not for the doctor. So there's a separate statute dealing with the hospital, the Emergency Treatment Blah Act, right? The Emergency Medical Treatment Non-Discrimination Bullshit Act. Yeah, whatever that is, right? That applies to the hospital, not the doctor. So the hospital might have obligations, but not the doctor. There apparently is no duty for the doctor to refer. I think, if I read this correctly. I'm going to go with that for the moment. Because you could view that as assisting, I suppose, among other reasons. So yeah, I don't think there is a duty to refer in this situation. Yeah, I mean, it is very improbable that magical fairy is somehow going to impart this knowledge. I find it very difficult that somehow I'm not a doctor, I'm not a trained physician, but I find it somehow difficult to believe that a trained physician could somehow, while the surgery is ongoing, somehow determine that the reason they're doing the D&C is because of an abortion-related procedure as opposed to a natural miscarriage. If there's some doctor out there that can somehow magically determine this is happening because of an abortion thing rather than a natural miscarriage thing, I don't know what to tell you. I don't know how you would make that determination. That seems like not a thing that would happen. Joe Lieberman died? That's unfortunate. Death is bad. I oppose death. Anyways, going back to the merits of the case at hand for a moment, I think the FDA is going to win the day, and it's just a question of how at this point. I don't even know that the Supreme Court strikes any of it down, because how do you get to standing? So I don't know that the Supreme Court strikes any of it down. And the advocate for the Alliance for Hippocratic Medicine didn't exactly do themselves any massive favors along the way. So, yeah. So I think you have to predict. I think the smart money is on the FDA winning and possibly just walking away with the whole thing. I wonder what Fantasy Scottus has to say about it. Sometimes they're wildly wrong, but it's fun to look at them anyway. There is a fantasy league for the Supreme Court, which I think is endlessly hilarious. Let's see. They think reverse 8-1. I don't know, man. Reverse 8-1. I don't know. If it is a reverse. Oh no, that makes sense. Yeah, reverse. Yeah, that makes sense because the FDA is the one challenging it, so they lost below. Yeah, they will reverse. Yeah, 8-1. That sounds right. If not 9-0. Yeah, that sounds right. I just forgot who was who. So they're predicting reverse 8-1. Yeah, that sounds about right. I wonder who the one would be. I don't know who the one would be. I don't know who's voting to uphold this at this point. I can't find any contenders. Roberts doesn't do it. Gorsuch, Amy Coney Barrett, Thomas. Maybe Thomas. If he wants to bitch slap them about something else completely. Maybe he dissents, but yeah, it's about Thomas, yeah, maybe. He probably dissents about something other than like what the thing is, but that's okay. But I don't know. I don't think Thomas is eager to find standing. So I don't know. Yeah, he's the only one that it could be. Yeah, probably that's right. It's probably the one. He's the only one that could be. But I don't even think that Thomas reverses. Because I don't think he finds standing. Unless he wants to bitch about standing doctrine. But I don't think this is the time. So I'm not really feeling it. Yeah, all the Supreme Court people thought the argument was dumb. When Gorsuch was backing Jackson, when Jackson was trying to like make a point, and then Gorsuch is like, "I got this. I'm gonna take your back." I knew we were in trouble. And then when Amy Coney Barrett, Catholic mother of 6, says, "Hey, how have you been harmed by the abortion pills?" And they give the answer, and she says, "That's it?" I mean, there's not a lot left at that point, guys. When Amy Coney Barrett says, "What's the harm from the abortion pills?" and then you answer, and she says, "Oh, is that all you got?" I mean, it's over. It's all over. It's just all over. If Amy Coney Barrett can't find the harm in the abortion pills, you're just fucked. Yeah. I mean, strictly speaking, it's the harm in the standing, but still, like, it's like, well, it's the same thing, because harm is one of the elements of standing. So it's like, how have you been harmed? It's like, this is how we've been harmed. That's all? Yeah. So strictly speaking, she was speaking about standing, not the abortion pills, but you understood my point. I think it'll be 9-0. I'm even not sure on what basis Thomas would dissent. Unless he just wants to attack standing doctrine, but I'm not sure now's a good time. Does he really want to uphold the FDA on this? Or does he want to strike down the FDA? I mean, maybe he does it because he's so pissed at them violating, like, the mailing thing? Maybe. I'm not sure what else you got. Yeah, 9-0, unless Thomas just wants to be difficult. Sounds about right. All right, guys. Well, that was fun. I had fun, and I hope you did too. Let's see. Who's streaming? When is Legal Bytes streaming? Oh, that's already happened. Is anyone streaming? It doesn't look like anyone's streaming. Making Law Simple is doing a Lego thing at 8 p.m., but that's too late. Aaron is streaming. You want to kick it over to Aaron on Scientology? Recovery Addict has a podcast. Let's see. Oh yeah, okay. Yeah, I'll kick you over to Recovery Addict. All right, cool. I'll kick you over to Recovery Addict. It looks like he looks like he's live. All right, guys, you know the drill. Be nice, say hi, be nice, all the rest of the things. I've been on Civil Law. Until later, my friends, I hope all's well. Cheers, my friends, and goodbye.